First time, Lordship. Oh,
Lordship, my lord, I am
May I be permitted to
Yes.
mention
application section.
a matter for inclusion in the list of second appeal hearing, Your Lordship. I am mentioning on notice.
No interim application pending.
No.
Ready for hearing.
Ready for hearing, paper book has been exchanged between the parties.
My lord, may I be
I'm-
permitted to mention?
One minute.
first time, Lordship. Oh,
Lordship, my lord, I am may I be permitted to
Yes.
mention
Application section.
a matter for inclusion in the list of second appeal hearing, Your Lordship. I am mentioning on notice.
No interim application pending.
No.
Ready for hearing.
Ready for hearing, paper book has been exchanged between the parties.
My lord, may I be permitted to mention?
first time, Lordship. Oh,
Audio পড়ে
Lordship, my lord,
may I be permitted to mention
যেটা লাস্টে এটা রেডি ফর হিয়ারিং, ঠিক আছে?
a
My lord, may I be permitted to mention one application for appropriate orders, my lord? There was a direction upon the appellants to file paper book. Now, my lord, that's at that time they were not filing the paper book, so I filed an application for appropriate orders to dismiss the appeal. Now, my lord, they have filed the paper book now, and but the application is pending, my lord. Otherwise, the matter is ready for hearing.
Except that application, no other application is pending.
No other application is pending.
I am appearing on behalf of the applicant.
I
am mentioned one extension
No,
of
it
interim
will-
order, my lord.
Both of you be in contact with the court officer. As soon as the file comes, it will be placed for under the heading to be mentioned thereafter for hearing.
Grateful.
Be prepared in the meantime.
Some interim order, my lord.
Hmm?
Extension of interim order. Yes, sir.
Is the record here?
Yes, my lord.
It is in the
Last,
it is in the list. It is in the list.
no, my lord. No, my lord. Inclusion for extension of interim order, my lord. This week,
I'm
interim order
I'm unable to
expired, my lord.
understand whether the matter is in the list or not.
Not mine.
So the record will have to be brought.
Yes, my lord.
Lordship, Section 5 application first time, Lordship.
My lord,
In both the cases.
Yes, Lordship.
my lord, upon notice, may I allowed to mention one section 5 application?
Lordship, may I be permitted to inclusion for a section 5 application?
Section 5.
I have intimated that side.
You have intimated.
Yes, Lordship.
May I please the Lordship, my lord? It's an application with regard to call for LCR, my lord. I have deposited the special messenger code sometimes in the month of July, as per the direction of the honorable court. Like,
23.
till date, my lord, LCR we have
Not been called.
not been came out. my lord. The appeal is otherwise ready for hearing. Paper book has been filed. There,
এইটা একটু দেখে নেবেন।
but kindly consider that to be mentioned so that my lord, a date of hearing can be fixed or whether LCR has come or it has been examined or not. But so far to the from
According to your
LCR has
information,
not come. Last
the
time
NCR
I
has
have
not been received.
not been received by the department. Thereafter, they will examine it. Thereafter, it will be. Kindly consider that to be mentioned.
my lord, one hearing matter, senior citizen. The plaintiff opposite party filed a title suit in 2005 for declaration and
You are praying for inclusion.
inclusion.
Mentioning to be signed.
Any application pending?
No, nothing pending.
No
And the
application pending.
opposite side is served upon, my lord.
Any interim application
No.
pending?
No.
Otherwise, it is ready for hearing.
Ready for, and the paper books are also ready for hearing.
Paper books have been exchanged.
Yes.
My lord, upon intimating the other opposite party, my lord, I am praying for inclusion of one second appeal, my lord, for extension of interim order, my lord.
Let the file come.
My lord,
It will be placed under the heading to be mentioned.
grateful. My lord, the interim order is going to expire on February 29, 2024, my lord.
What did you do during the meantime? There was a court in charge.
My lord.
I am mentioning
In
for
person.
my
In person.
in person. Pending second appeal petition.
Any application pending? Any application pending?
File now second appeal section.
আচ্ছা ইন্টারভিউ অ্যাপ্লিকেশন আছে না? কেন আছে? Be in contact with the court officer.
Tender.
Yes.
So this is an application that section 5 is pending. That has been already mentioned before Mala Justice Prosenjit Pisas in the meantime, but that
Who
day
was in
was,
charge?
yes, lost. But the matter when was listed, that day was not taken due to some resolution. And thereafter it was mentioned before my Lord Justice, and thereafter also it was not
Section
taken
5
for
application.
section 5 application.
Let the file come.
The lordship, the 4th March is the date fixed. So the execution case is pending. So lordship kindly fix it any.
First of all, let the file come. Thereafter, it will be placed under the heading to be mentioned. Thereafter, let us see.
The record is lying in code number 652.
You have mentioned it.
Yes, I have already mentioned this. It is lying on.
No, in the mentioning slip, it has been mentioned.
No, that is not. But the file is lying in the system. So for I am concerned that it has been in the record. So I will communicate that thing.
Be in contact with the court officer. Yes.
Actually, may I mention a second appeal, my lord, along with an application under order 40 or rule 27, my lord. Now, my lord, the matter
Order
was,
41 Rule 27 will be taken up along with
My
the
lord.
appeal.
my lord, deeply obliged. It was taken up by his lordship, my lord.
Any other application pending?
No, my lord, there is no other application
No other
pending.
application pending.
But my lord, the
Paper books are ready.
paper books are ready, my lord. There was also a direction was
For the appellant,
I am for the respondent. my lord.
respondent. Have you received the copy of the paper book?
Yes, my lord. We have only prepared the paper book
So you have
because
prepared the paper
they have not prepared the paper book. And my lord, because the applicant did not prepare the paper book, my lord, there was a direction from the Honorable Supreme Court as well in this matter, my lord, that to be taken, the matter should be taken up within 6 months. That was passed way back in 2021, my lord. Now, my lord, thereafter, my lord, my lord Justice Siddhartha Roy Choudhury was pleased to take up the matter, my lord.
You give the pensioning slip.
My lord.
In contact with the court officer. What do we do? It had to
And one substitution application.
the matter is in the list.
Yes, ma'am. No, and it is not in the list, madam.
It is required to be included.
Grateful to your lordship.
Have you served copy upon the other side?
It's substitution application. After substitution, it will be
Oh,
served.
there's no other. The appellant has expired.
Yes, madam.
Sole appellant.
Sole applicant.
I beg to appeal for the appellant, my lord. But I'm being led by Mr. Srijit Chakraborty.
Lord, I appear on behalf of the respondents. The matter is ready, my lord. Your lordship will be.
On the last occasion, my lord, Mr. Chakraborty apprised your lordship that the can number 2, that is the modification application, that is pending.
Can 1 of 2016.
Can 2 of 2021.
Step by step, let us come. There's one application being can 1 of 2016. Is there any application pending?
The can 1 that has been disposed of my lord, by the order dated 21st December 2017, passed by the Honorable Division Bench at the time of admission. That was the application for stay.
That has been disposed of. A review was filed, that was rejected.
Admitted on?
It is admitted on, my lord, 21st December 2017.
Orders December 2017.
17, my lord.
Substantial questions of law, 1, 2, 3, 4, 4 substantial questions of law frame.
Yes.
And oh,
Stay was conditional.
can one of 2016 correspond to old number 2792 of 2016?
Yes, yes,
my lord.
2792.
That is this. Mm,
Page 5 of the order, your lordship will see.
The payment of a lump sum of this payment.
বলে দিচ্ছি, হ্যাঁ। আরে ইনফরমেশন ফাইল করলে ওটা চলে
না এখন চলে আসে
The said application was in respect of occupational charge.
occupational.
In respect, can number 1, my lord.
Yes.
Can number 1 is an application for stay.
Stay
It's an application for
with
stay
the
of
condition.
Yes, that has been allowed.
Point of time the applicant was paying rent and occupational charge 2,700.
This is the application for stay of the execution case.
Withdrawn on such terms. Respondent and the applicant pays 5,83,200 paid.
Yes.
You have received?
No, but paid, 4 lakhs has been paid. I tell you, lordship, thereafter, my lord, I filed a modification application. That is can 2. That is pending before this honorable court, my lord, before the division bench. And
No
in the
copy
meantime,
has
my
been
lord,
served upon us.
that is separate. I don't
And
know, my
a
lord,
review
why
was filed. Review was filed.
review in respect of
This order, and that was rejected. Therefore,
Allow me
not
to
can
finish.
to whether it is maintainable or not is one more thing.
Allow me to finish, my lord.
Just
We
to
have
delay the
filed
matter.
Can 2 with regard to the modification of the admission order. I tell you, lordship, why? Because in terms of the order,
Modification of the order dated 2017.
modification of the order dated 21st December 2017. What is that?
2017.
With regard to the amount,
You have filed during the year 2021.
21. Because I tell you, lordship, why? In the meantime,
What about can 4 of 2023?
can 4, this is our application, my lord. Our water connection has been stopped by the respondent.
Can
Okay,
5
that's can 5 is their application.
For appropriate orders that has been disposed of.
No,
That was to expedite the matter so that the matter can be taken up and disposed of. Finally,
when the matter can be taken up?
My lord, I tell you, lordship,
Tomorrow?
LCR has not yet been come.
LCR has come.
It has been examined on the LCR is not in record, my lord. Let LCR be come. Let the modification application be here out.
No, Lord Council, all the matters will be taken up. All the
Simultaneously.
applications will be taken
Very
up.
well, my lord. Let my application can 4
No,
may be
no,
taken
all
up
the
because
applications will be taken up together. Prabhu.
very well, my lord. Kindly keep the date.
A date, my lord, so that the matter can be disposed of at the earliest, my lord.
Informal
that is
document
ready.
has been prepared by them, my lord.
By them?
They have,
Yes, because they were
have
delaying
filed-
it, we had to do it.
They have filed in terms of can 3.
Latter order, latter order.
Yes, in respect of can 3.
Initially it was directed upon the appellant.
Yes.
So, let the LCR come. ठीक है? अच्छा, हाँ, LCR যদি
Milord, it's in the department. I could gather, Milord, it's from the department.
full stop. Considering the submissions of the learned counsels representing the appellant and the respondent, let the LCR be brought from the department. Full stop. Let the matter be fixed on
As any day your lordship says, I'm ready.
With regard to the application, what kindly fixed next week,
all the applications will be taken up.
my lord.
Next week, which date?
Monday?
No. You mentioned.
Sir?
According to your convenience.
Lordship will take it up on Tuesday. For date
No, not according to his convenience.
Okay.
No.
Yes,
My lord, I leave it to my lord. Adds my lord.
Tuesday week.
6th, subject to my lord's pleasure. Sorry. 5th.
5th of March.
5th of March. Under the heading? Let it be under the heading to be mentioned. Let the LCR be received by this court thereafter.
And lordship will add a line, Lord, for fixing the date of final hearing. So that
5th March.
If the LCR is received, then
no, it just come, my lord. I have ascertained from a learned
to be
ওইটার অ্যাপ্লিকেশনটা পেন্ডিং কিনা
That is pending.
for hearing under the
জজ সাহেব কি বলছেন
জজ সাহেব বলেছেন তোমাকে আগে শুনবে ঠিক আছে
5th of March.
But instead of 5th of March, 5th and 6th,
will be under the heading to be mentioned.
but
On
I
that
may have
date-
some difficulty on 5th and 6th, my lord.
On that date, the hearing, the date will be fixed.
But I may not be, I wouldn't be able.
Then
And instead of 5th and 6th, my lord, I'll keep it on the next week. Instead of 5th and 6th, any day, my lord, commencing the with 11.
ডেট ফিক্স হবে তাতেও তোমার আপত্তি
Sir, can I not address the court?
হ্যাঁ নিশ্চয়ই
তাহলে আপনি এরকম বলছেন কেন?
11th of March.
Yes, I'm
11th
addressing
of
the court,
March.
sir. I'm grateful to Lord. But there are 3 applications pending, perhaps, Lord. Can 2, Can 4, and Can 5.
All the applications will be taken up
together.
Can 2, ঠিক আছে ওদিন আসুক না 11 তারিখ তখন আমরা অ্যাড্রেস করব উইল অ্যাড্রেস ইউর লর্ডশিপ
I'm grateful to you.
Yes, ma'am. Hello, defendant is the appellant before your lordship.
My lord, I am for the respondent plaintiff, my lord.
My lord, we are very grateful to your lordship. Lordship, we could not find, we missed the list. That is why we could not appear on several occasions, lordship. We are very grateful to your lordship for sending administrative notice.
For 3 consecutive days, so let the administrative notice.
Defendant is the yes, yes.
Mahasena Khatun,
Khatun.
alias Masina Khatun.
Masina Khatun.
You are representing
Mohammad
Sheikh
Rajesh.
Mohammad Rajesh.
Yes, my lord. My lord, defendants is the appellants before your lordship. Appeal was admitted on lordship 11 July 2016, and on application for stay is pending.
Step by step.
Lordship. July 2016. Subject to correction of your lordship.
We take the
Yes, 11 July 2016.
Lordship.
1, 2, 3 substantial questions of law have been framed.
Lordship.
Now, how many applications are pending?
Well,
I
only
think
one.
Only one lordship application for
See,
stay.
this reveals that can 1 of 2016, can 2 of 2017.
My lord, 2017 can has already been disposed of. We have filed on. My lord, it was disposed of on 10, my lord, 10 to 2023, my lord. It was an application for expeditious disposal and
10/10/2023.
Yes, my lord. It was an application for expeditious disposal and deduction for paper book was given to us, my lord. We have already prepared the paper books and filed and served, my lord.
Lordship,
Have you received-
she served me, but my lord, I
That is
could not
not
find
being-
out.
That
I
is
could
not
not.
being traceable.
Yes, my lord, this is the difficulty. Lordship.
Yes, I have already told her to get a Xerox
Yes,
copy.
yes,
from
I
me.
can get a Xerox copy of paper book, lordship.
There will be no order in this regard, as already it has been served upon you. 23. The requisites be accepted notice.
There
of
is a
application.
direction to call for the record. I think lordship, LCR is in department.
No, as regards to the can 2, yes, can 2 of 2017, though the appeal was admitted on substantial questions of law.
10/10/2023, my lord.
The
Disposal
respondent
is not
the requisite number of paper
Yeah.
books.
No, it is-
Department is right to call for the lower court record and place the same before this court
no.
will be listed for hearing on 30/11.
Well, no, formally, it was not recorded formally, but my lord, direction was given.
That the said application has been disposed of. It is not.
Not recorded formally, my lord.
Recorded.
So now, can one refers to
Stay, my lord.
Application for stay, lordship.
that has not been heard.
My lord,
Heard, but is pending.
So it is required to be heard.
Required to be disposed of.
my lord, if your lordship.
Suit for eviction.
Yes, my lord,
Eviction of license.
Eviction of
Eviction
license.
licensee is the they allege that the Morsina Khatun is the licensee, who is the in fact who is the Jathaima of the respondent.
Both of you are ready for hearing?
My lord, not today, my lord.
Not today.
No.
But are
Let
you
it be
ready?
listed.
Yes, my lord. Your
Let
lordship.
it be listed.
The matter can be taken up for hearing.
Yes, my lord.
Lordship.
When?
After 9th, lordship. After 9th.
Yeah.
An LCR can be tagged,
LCR.
lordship. It is in department.
The learned counsel. Acha. The appellant and the respondent are being represented by respective learned counsels. Full stop. The LCR. আচ্ছা প্রবিরও LCR এখানে আসেনি তো?
Yes, my lord.
Today itself, during the course of the day?
Yes, lordship.
The learned counsel representing the respondent submits that the application being can 2 of 2017 has been disposed of. Wide order dated 10/10/2023. Full stop. Both the learned counsels. On going through the paragraph, on going through the order dated 10/10/2023. This court do not find any formal order as regards to disposal of the said application being can 2 of 2017. Full stop. Full stop. Paragraph. As regards to can 1 of 2016, the learned counsels submit that the said application has been preferred, praying for stay. Full stop. Both the learned counsels submit that they are otherwise ready for hearing of the instant second appeal. Considering the fact that the learned counsels are ready for hearing of the second appeal, and paper books have already been prepared and exchanged, and it is otherwise ready for hearing, let the matter appear on
After 9th, Lordship.
which day?
10.
10th Saturday. No,
10 count.
10th Sunday. Apart from 10th, whichever day.
We leave to your Lordship.
We leave-
Lordship.
No. You state 11th Monday, 12th Tuesday, whichever day.
12th, my lord.
12th. Let the matter appear on 12th of March under the heading hearing. As so stays
Stays there.
stays there interim.
There.
Interim.
Stays there. Yes, till the hearing of the application.
Dated at the time of admission.
Yes. 11 July 2016.
Let this appeal be included in the list for makes sense. The appellant that will collaborate with service of next date of hearing. Not charge. Appellant that will serve copy. Till the disposal of this application.
Till the disposal of it may be till the disposal of the appeal. Yes. Stay.
The disposal of not till the disposal of the appeal, but till the disposal of the application.
Yes, there is till the disposal of the application. But if it is disposed of, till the disposal of the appeal.
That will be in future.
Yes.
Not yet. As both the learned counsels are ready for hearing. So so on consent of both sides, the matter is fixed on 11th of March. 12th of March under the heading hearing.
May we given liberty to inspect the file, my lord.
Yes, during the course of the day, both of you, in presence of both sides.
Yes.
Inspection be made in presence of both sides. Provido in.
For my lord, learned advocate Shravani Shankar appearing for the petitioner, she has engaged in code number 35 and praying for past development.
I have for the respondent.
Respondent. Then. Are you aware of the record?
No, my lord.
Learned counsel, any application pending?
No application has been stopped upon me. So far, my knowledge
This also does not reveal any pendency of any application.
Yes. But there is no stay. So far, my knowledge goes, Malak, at the time of admission,
Okay, that at present we are not granting any stay. Decree less the appeal and connected application second period of the. There is an order to this effect dated 25th of January 2023. We are making it clear that at present we are not granting any stay of the impugned judgment
Yes,
and
madam.
decree.
That's why I am submitting.
Prabhu, NCR ঠিক আছে? Ready? Filed.
I have I have not been received or supplied the paper.
It has been prepared. It has been prepared by the appellant. So during the course of the day, have an inspection of the file and let the matter be fixed. Paper books be served. Paper book.
Paper book.
Be served.
Okay.
What if she can't understand? Sorry.
She will be. Do not
Actually, my
paper
lord,
book. You have filed the paper book. Let a paper book be served upon the respondent.
Room number 9 এ বসে আমি, হ্যাঁ, room number 9.
When the matter can be taken up for hearing,
as your
have a discussion with your senior and inform the court.
okay.
Go outside. Neil, the learned counsel representing the appellant and the respondent are present. From the record, it reveals that no interim application is pending. LCR has been received. Paper book have been prepared. কোথায় দেখাচ্ছে? Chart. Oh, the chart.
This 4.
Item number 4.
My love.
Oh, 10/1 of 2017 is pending.
But I have not been served up. Him.
Item number 3 has.
That can possibly stay. Possibly, which was not heard out and grant.
So can 2 of 2022, can 3 of 2000, these are applications for restoration of the appeal and condonation of delay in preparing the application. Let affidavits be exchanged to the appeal according to the following direction. Affidavit in opposition reply may be filed. But it can অনেকগুলো pending হয়।
May I clear?
No, counsel, 3 applications are pending.
Of 2, my lord, section 5 and section subsection petition have been allowed. Section 5 application and also subsection application have been registration petition have been allowed by their lordships, the Honorable Justice IP Mukherjee
And Bishop Chaudhary.
My lord, deep love this.
In respect of order dated 25th of January 2023, in respect of CAN 1 of 2017,
My lord,
we are not granting any stay of the impugned judgment and decree.
deep love this.
In respect of CAN 2 of 2022 and CAN 3 of 2022, these applications for restoration of the appeal and condonation of delay. Affidavit in opposition by 10th February 2023. So those two
are exchanged, my lord.
Pending.
পেপার বুক জমা দিতে হয় এগুলো সাফ করতে হবে দেখলাম উনি বলছে পাইনি
কোনটা দেওয়া হয়েছে? না, পেপার দেওয়া হয়নি। কেন বাদে গেল? সেইটা বলুন, আমাকে দেননি। তাহলে ভটকে বলছেন কেন আপনি আমাকে দিয়েছেন?
টাইম কবে না
Wide order dated 5th of June 2023.
When the matter was admitted by the lordships of the opposite standard.
Discussions and findings made herein above, both applications are allowed. CAN 2 of 2022 and CAN 3 of 2022 both have been allowed.
My lord.
Wide order dated 5th of June 2023.
My lord.
The instant appeal is restored to its original and file and number, subject to the deposit of cost assessed at rupees 5,000 with the SLSA within a week from date. In the event the said amount is deposited within time frame, the same shall be kept in account earmarked for juvenile. In default, this order shall stand automatically recalled.
My lord, I am praying for liberty for correction, my lord. There have some defects, my lord. As per
Correction of?
ডিফেক্টটা কি বলুন সেটা
Actually,
Passed over.
ও
Passed over.
ভ্যালুয়েশন ডিফেক্ট
valuation defect, my lord.
Let your senior come. The matter is being passed over.
টাইম মে বি ফিক্সড 12
12.
বিপ্লব স্যার
My lord, in this matter, I am for the respondent, my lord.
But I am for the appellant.
Paper book has been already been served, my
Well, there was one difficulty that I am faced today. That is, paper book was prepared before the COVID intervened, and so it was in the Milord conquest paper and the Milord in the legal form. When I am told that when I have gone to file it, I was told to get it in A4 size. I have got it ready. One accommodation may be granted, my lord. I'll file it with the department, my lord, and the matter can be heard out any day.
My lord, it is only technical matter. I have no objection. But any this paper book is your lordship cap.
Otherwise, both of you are ready for
Both of us are ready. One application, my lord, a stay application. It was when our ad interim stay was granted at the initial stage while admitting the appeal, and that application is still pending. It was still disposal of the application. Now my learned friend may have filed.
One of 2016.
My lord.
And can 2 of 2020.
That is at the instance of my learned friend, can 2.
My lord, can 2 I have not placed, my lord. My lord, that is for early hearing. My lord, can 2 I have filed for early hearing.
It need not be taken up for hearing. This is
Lord, division bench decided by Justice Shonji Banerjee, my lord, admitted the appeal. Question of law was formulated.
Four substantial questions of law have been
My lord,
framed.
my lord. It is
as regards to the can 1 of 2000 can 1 of 2016.
It was moved, and an order of stay was granted till disposal of that application.
Thereafter,
my lord, LCR has arrived and we have prepared the paper book, and a can 2 has been filed by my learned friend.
What has been the fate of the third application?
But the application is still pending.
Still pending.
Because the order, my lord, clearly says that
My
till
lord, stay
disposal
application has already been annexed in this paper book.
My
My lord, no stay granted, my lord. My lord, kindly see this order sheet, my lord.
It is recorded that the amount claimed by the respondent or payable to the respondent has not been quantified, and accordingly no deposit can be sought at this stage. Well, and since it prima facie appears that notwithstanding the said circular of January 7, 1998, it was left to the individual to augment their resources if they wish to implement the recommendations of the Fifth Pay Commission. The judgment and decree impugned will remain stayed. The judgment and decree impugned will remain stayed till the disposal of the application. It will be open to the appropriate bench taking up the second appeal to impose such conditions as may be deemed fit at the time of the disposal of the application.
So there is an order of stay, but the application is still pending.
When it can be fixed?
My lord, any day, my lord, as your lord.
Application.
My lord, if I, my lord,
entire matter may be heard.
my lord, can be taken now.
My lord, it is finally
If the lordship so pleases, I can move the application.
No, then. The learned counsel representing the appellants and learned counsel representing the respondent submits that the instant second appeal
পাওয়া যাচ্ছে না, এটা আমরা ফাইল করেছি, পাওয়া যাচ্ছে না।
second appeal can be heard out.
এইটাই আমার যেটা সেকেন্ড ক্যান যেটা এটা করেছিলাম
on consent of both sides.
আপনারটা নয়।
The instant second appeal is being fixed under the heading hearing on
Not any day, my lord, in March, my lord, as your lordship pleases. At least, my lord, two weeks time, my lord, maybe.
Second appeal, the second appeal will be heard of.
My lord.
Yes, madam.
Let it be any time after the fortnight, and I need to take instruction whether there has been any development in execution or not.
18th of March.
My lord.
Another in 18, any other day, 18, I have personal difficulties.
Whichever day you recommend, which day?
My lord, that is March. On the first week of April, any day.
Why April? Why
My
not
lord,
March?
next week, my lord, the third week is a holiday. Most of the time, my lord.
That is in the respect to the fourth week.
Fourth week.
29th is
Third week,
Good Friday.
19 or 20, my lord, it fixed. 19 and 20.
Got it, council?
My lord, I have no objection to respect.
20th.
Grateful.
20th of March, Wednesday. কি বলে এলসিআর তো আছে on consent.
Deeply obliged.
Have an inspection.
My lord.
কদিন লাগবে
The matter is made returnable on 20th of March. Right?
20th
of March.
20th of March 20 hearing তো কত হলো আইটেম কত হলো
Number 10, my lord, I'm appearing for the petition. As per your lordship direction, I have served the copy upon the opposite parties twice, as they have not received that return back I sub upon the learned advocate appearing before the learned court below. In execution proceeding.
Mr. Ghoshal, are you representing the respondent?
No. Next
What is
matter.
the next?
Next matter.
What about the respondent, learned counsel?
My lord.
Respondent.
My lord, I have, as per your lordship, I have subbed the copy. My lord, kindly go through the record.
The learned counsel representing the appellant is present with furnishes affidavit of service that should be kept with the record. On going through the address.
Corrected the address. Then I have
After correction, you have served.
Served.
On
Twice.
going-
They have not received.
On going to the address mentioned in the said affidavit of service and comparing with the address mentioned in the decree, which is provided along with the memorandum of appeal, the addresses are not tallying. In such circumstance, learned counsel appearing on behalf of the appellants is requested to serve a fresh notice upon all the three respondents. Notice been served upon all the three respondents.
My lord, all are returned back. My lord, with the endorsement, not known. One is not known, and another is not found.
Third one.
Third one.
In respect of
Refused.
refused.
Refusal is a good service as per section 21 of the General Clause Act.
I'm not going into that aspect. Refusal is good service, but
My lord, thereafter I serve the copy upon the learned advocate who is representing them before the learned court below. The last,
so who has refused?
My lord, refuses by Seema Choudhury. Sonia Choudhury. এইগুলো দাও না।
Who is the respondent number?
Respondent number.
The three respondents are Bablu Sarkar,
Bablu Sarkar refused.
Refused.
Bablu Sarkar not found, my lord. First line. Bablu, Basanti and Dhirendra. And who is appearing for Bablu and Basanti in the learned court below, he has received.
Bablu Sarkar, not found. So in respect of Bablu Sarkar, not served, not found.
Not found.
Second one, Basanti Choudhury.
Second person.
Basanti Choudhury cannot be located. Dhirendra Nath Das.
Third person.
D-I-R-E-N. Dhirendra.
My lord, that was written.
Dhirendra Nath Das cannot be located.
So lastly, I have served the copy upon the learned advocate who is representing them before the learned court below. My lord, kindly come to the last annexure, last affidavit of service, last annexure.
First of all, these three are not in respect of this instant appeal.
My lord, I am praying for apology, my lord. My lord, I am praying for apology.
So, what to be done now?
Now, my lord, kindly come to the last annexure. That the learned advocate representing them has received the same. Page 15, my lord. Affidavit of service.
He was representing
Both Bablu and Basanti.
Excuse for 5 minutes.
in the instant appeal, the respondents have never been represented. No?
Though they are appearing in the learned court below, they are not came to this honorable court. My lord, that's why I came to this court. That why they have not coming.
So what can be done? Not found, not found, not found.
But my lord, service has been affected as the learned advocate who is representing them before the learned court below, he has received the same. So information should have been given to them.
He might be representing in the court below, but not here.
My lord, kindly go through the page 15. My lord, he has received the same.
He might be representing the respondents in the court below.
My lord, when the execution court proceeding, I am praying for a stay of the execution proceeding. My lord, when the person who is representing the person who, for execution, he has received the same copy. My lord, can it not be the person who has already the person on this appeal has received?
What is the address of the respondents?
My lord, after changing the address, I have given my lord in handwriting, my lord.
Malda.
Dokhin
Malda.
Malda, my lord.
All three are of Malda.
All the three are Malda. The appeal is from Malda. Suit for declaration, my lord. What is the suit, my lord? My lord, kindly go through the list of dates, my lord, once.
You serve once again.
I would not found, my lord, their address.
And have you verified the addresses which have been
my lord
mentioned in the memo of appeal?
My lord.
With
my lord, degree of the lower court. My lord, in the appeal court, degree has not been given the address. My lord, kindly go through the lower court degree. On the previous occasion, my lord has been gone through it. My lord, the execution would have happened, my lord. If there is no order of stay, the execution would have happened. And my lord, I have already served the copy upon the learned advocate.
When is the next date fixed?
Today.
Huh?
Today is
Which
the
one?
date.
What?
In the execution case. For police help.
Can you show that it is fixed today?
My lord, can I show your lordship?
Good for partition.
No, my lord. It is a suit for declaration.
It is mentioned here. Only for partition?
My lord, there is a two property belongs to one person. My lord, kindly come to my. I have show your lordship the list of date. My lord, kindly once. My lord, kindly take the list of date once.
In the judgment, it is mentioned suit filed with the plaintiff for declaration of title, recovery
lord,
of past
my
possession
lord.
by evicting the defendants.
But there is no prayer for first possession, and there is no prayer for eviction. That is
For
written, my
declaration of
lord.
title, recovery of khas possession.
My lord, kindly go through the plaint itself once. Oh, plaintiff copy.
Not yet started hearing. I'll have to go through the plaint now.
My lord, once kindly.
The matter will be taken up later on. Let the other matters be taken up, it will be taken up later on. Pass over. Next.
For the respondent opposite party. Respondent plaintiff. But the matter is otherwise ready, but the difficulty is that there is a specific order of conditional stay of payment of occupational charges.
Amounting rupees?
2,000 per month till disposal of the appeal.
Not being
That
paid.
is not being properly complied with. That is there to satisfy my lord that they have complied with that order. Other than that order should go. That is order dated. Lots of kindly see order dated 1/10/1919, 2019. Order dated 1/10/2019.
Admission.
No, that's subsequently. The last page, my lord can kindly excuse my impertinence. Kindly see last page, the relevant portion. Last page, page 5.
Order dated
1/10/2019. Stay granted on condition of payment of occupational charges 2,000 per month. They say they have paid. They have to satisfy the court. Or I can my publish, I can hand up my copy.
No, let me find it from here.
Justice Vivek Chaudhary's judgment order.
23rd of April.
It is now 1/10/2019. 1/10/2019 can 3775 of 2017.
Yes, 1st of October.
Kindly see the kindly excuse my impertinence. See the come to last page first. You must my lord can get the
Page 5.
Page 5, last page.
For the reasons stated above, the instant application is allowed on contest. The impugned judgment or decree passed in title appeal be stayed till the disposal of the instant appeal on condition that the petitioner shall go on paying and or depositing occupational charges at the rate of rupees 2,000 per month from the date of this order till the disposal of the instant appeal.
Unless there is satisfied, the interim order should go.
What about the appellant?
Moreover, the appeal is otherwise ready.
Otherwise ready.
Kindly see, but my lord knows there are judgments that even the
If you agree, then the matter can be taken up for hearing. Suit for eviction.
Suit for declaration challenging a deed of gift. The defense is of tenancy. Any other marriage of the deed is under question. Declaratory suit.
Reversal or affirmation?
Reversal.
Reversal.
Suffered, then I succeeded, then again I suffered.
If you agree, then the matter can be taken up for hearing.
I have no objection. No, question is that
you are sitting up on the occupational charge.
No, solemn order should be complied with. There is non-compliance of the court's order. Apart from the question, no question of the 2,000 or 3,000 or something. It's a question of the compliance of the solemn order. And my lord knows there are judgments that
not being paid since
that they are to satisfy. They say they are paid. They are to because they still have the receipt. They are paid or challan. But otherwise, it would be court's order should be honored, irrespective of what I require or not.
True, but
They have filed challan only up to last, only challan is to June 2023 as per as per CAN 3. As per CAN 3, only one challan has been placed, that is on.
till the June 2023, it has been paid regularly.
No, the only one challan has been said.
Only one challan.
One challan has been sent placed before the court. We must honor the court's order.
Let the matter be fixed at 12:15. Let the appellant appear and
Let
submit.
us take a chance.
The,
My lord knows there are judgments that even in case of court, non-compliant court, even the plaint should go, the pleading should go.
No, let them submit. Let the matter be fixed.
It's a question of showing respect to the court's order.
15 minutes past 12.
12:15.
12:15.
I'm grateful. Otherwise, matter is ready. We are ready. But this is to be honored.
Next.
Milord, I am for the appellant, Milord. Pursuant to your lordship's direction, Milord.
Appellant, you are for the respondent.
Passed on 9th of February. Milord, I have served upon all the respondents and particularly one Mr.
All the respondents.
One Mr. Bhaskar Nandi, your lordship directed, appearing on behalf of respondent number 2 and 3. Now, apart from that, Milord, 1A, 1B, 1C, 2, 1A, 1B, 1C.
File is not here at this present moment.
Not today.
No, Milord. It needs to be heard, Milord. Old hapless landlady.
Unless the file is stressed, how can it be taken
No,
up?
then pass it over. Your lordship can well pass it over.
Suffering from.
Then, Milord.
The regular peon.
Yes.
Is
I understand. Yes.
He is having a.
I understand. Milord. Then kindly keep it on day after tomorrow.
Day after tomorrow. Day after tomorrow.
Tomorrow I have got some difficulty. At the same position.
Day after tomorrow था এটা নোট রাখুন Essay 100 of 2019. Day after tomorrow. In the meantime, let it be traced out. Lord Councils have an inspection of the file tomorrow. Not today, because the absence of the peon.
Milord, tomorrow I have got some difficulty, Milord. Inspection I will make on day after tomorrow.
Yes.
At the very first.
May I say one example? Instead of 12:15 today, uncertainty will be there. We can, my subject to Milord's convenience, day after tomorrow, we shall give a notice. The Milord has fixed it.
That will be better. That will be better.
Day after tomorrow, we shall give a notice, fixing a time.
Yes. That will be better.
Otherwise, it will be uncertainty.
Item number 11.
Item number 11.
Item number 11.
Because it is uncertain.
None is representing the appellant. Full stop. আচ্ছা ওই বোর্ডটা 11 করে দিবেন none is representing the appellant. Learned counsel representing the respondent submits that the appellant is not paying the occupational charge of rupees 2,000 per month. He further submits that the instant appeal is otherwise ready for hearing. NCRS Provivo
Ready.
you have
We have prepared also gist of arguments also. Out of that, I have to assist your lordship.
paper book has been prepared by you or the appellant.
Yeah, by respondent.
So let us find
About
the
that, no
willingness.
controversy.
Let us find the willingness of the appellant.
Let us see, my lord.
Others ready for hearing. Let the matter appear. No, he further submits. Let the matter appear on 28th. Let the matter appear on 28th of February 2024. In the meantime, the learned counsel representing the respondent is requested to serve notice upon the learned counsel representing the appellant, intimating that the instant matter will be taken up on 28th of February 2024.
Grateful, lordship.
Under the heading no application. Any application pending? With the appeal that will be
That order is that will dispose along with the appeal.
Oh, can 3 of 2022.
That was regarding preparation of paper book and default. That has become redundant now.
Item number 11. No other application is pending.
Because it is running in the list for some time. As for final hearing.
No other application is pending.
Right.
That does not require to be heard of as a paper
already
has already
disposed of.
prepared.
Disposed of.
Let the matter appear on. Taken up for hearing on 28th of February. 28th of February under the heading hearing.
I'm grateful also.
Let them appear and submit as regards to payment.
It may retain its position.
Yes.
Lordship, I'm appealing for the appellant, your lordship. Yes, your lordship. There's a difficulty, your lordship, that we are not been able to contact with our client, your lordship, for instruction. I'm praying for 3 weeks accommodation, your lordship.
No, Lord Counsel.
For 3 week accommodation, lordship, we have not having an instruction to appear on this. Take any.
Second appeal of 2019, Lord Counsel.
Yes, your lordship. I appreciate that. If your lordship.
Representative respondent.
Mr. Rita Patru is appearing for the respondent. She has not come to court as per instruction. I'm saying that.
Lordship, kindly grants her 2 weeks accommodation, your lordship.
Can 3 of 2000. Can name. Colonel. The learned advocate representing the appellant submits that he has not been able to administrative notice issue করতে বলেছে Most humbly submitted, the administrative notices were issued upon sole appellant and respondent number for the unserved postal articles and respondent number 24 returned to the department with an endorsement deceased. Learned counsel, whether you are representing whom?
I'm representing the respondent, my lord.
All the
All the
respondents. All
respondent.
the respondents.
Rita Patra is happy.
Into the department and enrolled deceased. Unserved postal articles upon, there was an earlier direction upon to have administrative notice upon both the appellant and the respondents. It is most humbly submitted that administrative notices were issued upon sole appellant. Sole appellant administrative notice has been issued. So no question does not arise as regards to non-information. And respondents number 1 core 2 1 year 2 to 5 by memo numbers at the unserved postal articles upon respondents number 2 and 4 have returned to the department with an endorsement deceased.
For substitution, we have to take an application.
No postal article upon the sole appellant and respondent has been received by the department. The postal track report, the current status of the item delivered and received. Only one application is pending, Can 3 of 2023. The learned counsel representing the appellant, seeks an accommodation of 2 weeks. Full stop. ওনার নামটা নিয়ে নেবেন, ঠিক আছে? Representing the respondents submits that the learned advocate representing the learned advocate on record representing the respondents has she has not come to court. Has not come to court today. Full stop. Considering the submission of the learned counsels, let the matter be fixed on February February 26 It is being fixed on 18th of March. Under the heading the interim application being Can 3 of 2023 is not in the file. Department is directed to trace the said file and said application and tag with the instant file. Can 3 of 2023. Under the heading application. Can 3 of 2023 is in respect of?
Yeah, I have to look at it also.
Under the heading application on 18th of March. For the appellant.
Yes, I'm for the appellant. Your lordship directed me to serve and
7 applications are pending, not today.
Yes.
Next.
Mr. Raju Bhattacharya is appearing on behalf of respondent number 7, 17 to 21, 31 to 33, 36, 40 to 46.
How many respondents are there?
So many respondents are there.
So many
In
respondents.
this matter, Your Lordship,
And he could
I am
not
for the
come
appellant.
due to his personal difficulty, could not come. I would kindly take up this matter and if it's in the next week.
Don't counsel.
मतलब Friday करो এই উইকটা বাদ দিয়ে and as your lordship
Fifth, next Tuesday.
Not this week, sir. Not this week.
Number 16, I am appearing on behalf of the appellant lordship.
For the respondent.
My lord, I am praying 2 days accommodation, my lord. If
You are representing
Representing the respondent, both the respondents.
both the
Both
respondents.
the respondent. Lordship, it came up to be mentioned that the matter is otherwise ready. Lordship has seen the earlier order recorded it.
There's one application pending. Can 1 of 2020?
That was for extension of interim order.
No, extension of interim order is CAN 2 and CAN 1 is application for stay of order of the learned trial. CAN 1 is a stay application.
Are you pressing upon the hearing of the said application or the matter can be taken up for hearing?
That application is, there is an interim order regarding that application. Regarding that application, affidavit were exchanged.
And the extension was
as-
granted. I was that
opposition to file kora nahi kintu court.
hearing.
Find the bill.
Opposition like the opposition Tawani.
আমাকে সার্ভ করা আছে opposition ফাইলে oppositionটা নেই
There's an affidavit in reply. Affidavit in reply has been filed in respect of CAN 1 of 2021.
Yes, lordship. Affidavit in opposition is
Opposition,
supposed to file by the.
We have served them, but
It is
It
not.
served advance copy was served upon me. Advance copy was served upon me, but that copy is not filed in the court's record. Shravani Sarkar.
Where is the affidavit in opposition?
opposition
It is not in the file.
Not in the file. We have served them advance copy. We'll file it.
Within the due course of
The due course of the day, it is ready. Lordship kindly fixes our day for hearing of the.
Are you pressing upon the hearing of the said application or can we
my lord, I
proceed
am
with the hearing of the
hearing
appeal?
of the second appeal.
Second appeal,
Yes.
but
Along with
during the course of this day only,
It's
the said affidavit in opposition be filed.
Paper book also filed.
Paper
before
book
the
and
court.
otherwise ready for.
Paper book is-
Otherwise, the matter is ready for hearing.
Proviro. Any direction required?
No, I will just. No direction, sir.
Within 1 p.m.
Within 1 p.m.
Essay 17 of 2022 তে Essay 17 of 2022
Yet.
So, the learned counsel representing the appellants,
Appellants. Two appellants,
Two
Sanatan Shah and Gopal Shah.
representing the appellants submits that she is not pressing upon the hearing of the application being CAN 1 of 2021.
My lord, can it be possible to hearing of the second appeal with that can application? There is no.
If the second appeal is disposed of, then
can
suit for
declaration.
Declaration. She further submits that LCRs are in the file. Paper book have been prepared. Paper book served. Paper books have been.
Paper books are already filed before the
Paper books
department.
have already been served, and the otherwise the instant appeal is ready for hearing. Full stop. On consent of both sides, the instant appeal is fixed for hearing.
First week of March.
Or
your lordship may,
date.
As your lordship may.
No.
April, anytime, first of actually, last part of March is a holiday.
Yes, last part of March is holiday, but first part of March is not a holiday. Holidays will be there. At least 8 holidays will be there in a month. So, which date?
6th March. 6th March. It is Wednesday, my lord. Next week.
6th March. During the course of the day, you
No,
file
I will
affidavit of opposition. There is no formal order being
No, I will
passed. Let the matter appear on 6th. On 6th of March. Under the heading hearing.
I am for respondents number 1, 2, 5, and 7. Each of the
1,
1, 2, 5, and 7. Add from the my lord section 5 application.
3 and 4 are not being represented. 3 and 4. Respondents number 3 and 4.
All have been served, my lord. This is my affidavit of service. Delivery has been confirmed. Section 5 application as well as substitution. কি কার্টার হয়ে অফিসে অ্যাপিয়ার করছে কার্টার হয়ে অ্যাপিয়ার করছে
আর এই নিশিকান্ত আর তো বাকি আবার তো অ্যাডিশনাল পার্টিতে তাদের নাম ঢুকে on the addition of party application, my lord.
Can 1 of 2022 is in respect of?
That one is in respect
Sunil and Nishikant.
My lord, respondent number 1, 2,
5 and 7.
and 7.
No. Can 2 of 2023 is in respect of addition
Addition of party and substitute.
Again,
addition of party. And
again,
can
my lord,
1
their name appears, said my lord.
As substituted. Yes.
Can 1.
Can 1 is for the limitation, my lord. It is section 5 application.
Section 5 application. It has not been admitted as yet.
No.
Oh. So, you are representing Anil Shodhar.
Anil, Pulin, Nishikanto, and Sudhir.
Anil,
Pulin, Nishikanto, and Sudhir.
Nishikanto and
Sudhir.
Who did? 1, 2,
Five
5,
and
and 7. In respect of the remaining respondents,
The remaining respondent, my lord, kindly have a look into application number 2, my lord. Their name has been repeated in as substituted here also. That means, my lord, they were already on record in respect of the appeal, but 3 persons' name were substituted subsequently. My lord,
substitution.
9A, B, and C. Kindly have a look into the cause title.
The appeal has been filed after death of the appellant.
No, after date of the appeal.
After death এটা করেছে লেখা আছে তাই addition of particular
After date of
এটা তো
Bimol
2020 মারা গেছে
Yes,
2022
Bimol Sardar. That is one of the respondent.
বিমলা সর্দার মারা গেছে 20
Yes, my lord. Respondent number 9.
22 appeal file হয়েছে
has it been served upon 3 Sunil Sardar?
Yes, my lord. My lord, I have written the affidavit of sir. Twice, my lord, it was served. Two affidavit of service are there, my services was there, my lord, in the record. It is not with me, but I shall.
Where the name of Sunil Sardar is revealing?
My lord, in application number 2.
No.
Hmm?
In the affidavit of service.
Affidavit of service, my lord, note, my lord, these receipts.
Yes, receipts.
Yes. All have been served, my lord. All the 15 persons.
Where is the name of Sunil Sardar?
Sunil. But let me check. Let me check my.
Because there are several
All have been
respondents.
sent. Hi. Yes, ma'am. Because Bimolawala Sardar died in the year 2022. My lord, after serving this notice, that was returned thereafter, my lord.
It has been stated in 14th January 2020.
Yes.
Check the file. The matter will be taken up afterwards. Being passed over for this present moment, it will be taken up afterwards.
Okay.
Go to the file in the meantime. Next.
But it is possible. Kindly, I am checking.
When you are ready, then you submit.
My lord, all have been sent, my lord.
Next.
18, my lord, we have instruction to appear on the respondent, lordship. We are yet to get the papers, lordship. Kindly takes it up on next week, lordship. We are for the respondents.
Who is representing the appellant? Appellants. Okay. In respect of Can 1 of 2023, there's a direction to serve the copy of the instant application. Have you received
Copy has been served upon my client. I am yet to receive it from my client. Therefore, I was praying for a week's time. My client has instructed me to appeal.
Who is representing the appellants? Nobody. Not today. Not today.
Lordship, kindly makes it not this week. I have to receive the paper from my client. He's from Bakuda, Lordship.
Not this week.
I'm grateful to your Lordship.
Talks of settlement is going on between the parties.
Who is representing the respondents?
I don't know, my lord. Pursuant to the direction passed by your lordship on earlier occasion, my lord, I serve copy upon the opposite party. Respondent opposite party. My lord, I have instruction, my lord.
The appellant is submit the notice has been served upon the respondent.
Going to settle the matter, my lord, out of
But
court.
earlier there was an direction of serving notice.
Yes, yes.
Upon the respondents. Has it been served?
Yes, I have served. Madam. I have served, but after, my lord, getting this notice, my lord, they are, my lord, talks of settlement, my lord, is going on between the parties, my lord. So I'm paying for, my lord, 1 month time. 1 month time, my lord. So that, my lord, by this time, my lord, they have to matter.
You file the affidavit of service.
My lord, it is with my salvation. I'm doing it, my lord, because talks of settlement is going on. That is the reason I
order to be passed in this situation.
On the pair of the appellant, let the matter, my lord, be adjourned for a month, my lord.
But to show that your bona fide.
Just to, my lord, to show my bona fide, my lord, I have served. I have to, my lord, file my affidavit of service. That's true, my lord. But
you file during the course of this day affidavit of service, then that order can be passed.
My lord.
During the course of the day, you file the affidavit of service.
My lord.
উনি অ্যাফিডেভিট সার্ভিস ফাইল করবেন, ঠিক আছে? অ্যাফিডেভিট সার্ভিসটা ফাইল করবেন, তারপর আমি অর্ডারটা পাস করে দিচ্ছি। The order is being passed, but
yes, I am in course of this. I my lord, hand it over to lordship's office.
The learned counsel representing the appellants submits that notices have been served upon both the respondents. Upon both the respondents. He further submits that during the course of this day, he shall furnish the affidavit of service. If the affidavit of service is filed during the course of this day, let the same be kept with the record. Full stop. The learned counsel representing the appellants further submits that there's a talk of settlement going on between the parties, and on this circumstance, he seeks an accommodation of a month, for a month. Let the considering the none is representing the respondents. Considering the submission of the learned counsel representing the appellants, let the matter appear on. Let it appear on 18th. On 18th of March.
Malad, grateful to your lordship.
Under the heading to be mentioned.
12 noon fixed matter, item 4.
Item
time is present, madam.
12 noon.
My lord.
Item number?
4, madam. 4.
4.
My lord.
Number 4. Achha. There's only one under the heading to be mentioned. Let that be taken up first. Thereafter.
My lord, my lord.
My lord, under instruction of the appellant advocate, I am praying for 1 week accommodation. 1 week accommodation. The respondent number 3 died.
I have for the respondent 1 and 2. Respondent 3 died.
Therefore, she have to take an step.
Number 3. Explaining the same steps. Steps are to be taken and 6 weeks accommodation for taking steps. Has the step not been taken as yet? Has the
My lord,
step not been taken as yet?
steps will be taken, my lord, shortly.
Will be taken
Huh.
after the passing of the period, statutory period. Colin, Babu. Item number 21. Can 1 of 2023 is in respect of?
Section 5.
Section 5. The learned counsel, learned advocate representing the appellants submits that you are seeking accommodation on the ground of the advocate on record.
Substitution. Furnish the substitution, filing the substitution. No, I am not advocate on record.
You are seeking accommodation on the ground of the learned advocate on record.
Or on advocate on record.
Seeks an accommodation on the ground of the learned advocate on record, representing the appellants. Full stop. The learned counsel representing the respondents submits that he is representing the respondent number 1 and respondent number 2. Full stop. No step. On going through the record, it reveals that no step as in respect of the respondent number 3. No step in respect of the respondent number 3, who is stated to have expired, has yet been taken. Full stop. Considering the prayer seeking accommodation, let the matter appear on
any day suitable. Just
this is a suitable day according to the court.
in this matter, I am not brief, my lord.
The second week of 4th of March. 4th of March.
Monthly list, my lord. Daily list. 6th of March.
Next Monday, 4th of March.
Monthly list.
Under the heading to be mentioned.
My lord, Passover matter 17, my lord. Let's check.
1 minute. Let us take up the item number 4, which has been fixed at 12 noon. ঠিক আছে বলে দিন
Item 3.
None is representing. Item number 3. None is representing either the appellant or the respondent. Let the matter appear tomorrow. Item number 4.
Number 4.
Item number 4, I am appearing on behalf of the appellant.
Yes. You are representing the respondent.
This one, sole respondent.
Sole respondent.
Well, there are some defects in the filing of the appeal lordship. But leave may be granted to cure the defect.
Perhaps in respect of valuation.
No, my lord, there are 5 defects. Not only the valuation.
There are a list of defects.
Yes, Lordship, there are 5 defects, my lord. Can leave may be granted to cure the
Learned
defect?
counsel, can it be at all cured? It has been filed during the year 2017.
The department says that if court directs that the defect can be cured.
The learned counsel representing the appellant submits that there are several defects which are required to be rectified and seeks accommodation on this ground.
Otherwise, the matter is ready for hearing. Paper book is already
But
filed.
these list of defects are required to be cured. The learned
Within 1 day, it can be cured.
within
1 day, it can be cured.
item
Yes,
number
Lordship.
4.
4, yes, Lordship.
There is one application pending. Can 1 of 2017
That application is for appropriate order.
appropriate order? So otherwise it is
Otherwise, it is ready for hearing.
if the
That can be disposed of, madam. That can maybe disposed of because
if the appellant intends to.
Proceed with the second appeal, Lordship.
If the appellant intends to proceed with the second appeal, then the matter can be taken up. Otherwise, ready.
That there were several defects which are required to be rectified and seeks accommodation on this.
When can it be fixed for hearing?
My lord, as well, Lordship may.
convenient as your lordship's convenient.
It can be fixed tomorrow, day after tomorrow. Which day?
Tomorrow it cannot be possible because there is some defect. My lord, it can be
I'm
fixed on
thinking.
next week.
Next week, madam.
Next week. Which date?
Next Wednesday, next Tuesday or Wednesday.
Wednesday. 6th of March.
Great.
The matter appear on 6th of March under the heading to be mentioned. On 5th of March. On 5th of March under the heading to be mentioned. Thereafter, the date will be fixed for hearing. 5th of March. To be mentioned under the heading to be mentioned.
এই আগে তো সকালবেলা দিদি ঠিক আছে থ্যাংক ইউ হ্যাঁ
Next. No. Learned counsel. It will be taken up. It will take some time. It will be taken up. Next.
Number 17.
17.
Yes, ma'am. Affidavit of service. That's a affidavit of service.
Have you made the
Yes, my
affidavit of service easier for the court
yes,
to understand?
yes, my lord. My lord,
One by one. Learned counsel.
yes.
One by
Respondent.
Respondent number 1 is being represented. Anil Shodhar. On behalf of 2, you are representing. In respect of 3, Sunil Shodhar.
Sunil Shodhar and Madan Shodhar. Respondent number 4.
3 and 4.
3 and 4, my lord. One is receipt number 8 and one is 9. One is 10. My lord, kindly have a look into
Page number.
page 6. Page 6 of affidavit of service.
Page 6.
Yes.
Sunil
My lord, the
Shodhar.
second one is Madan Shodhar.
Second one is Madan Shodhar.
Shodhar. And my lord,
Third one is Sunil
third is
Shodhar.
then fourth one is Pulin Shodhar, the third respondent.
Pulin is being represented.
No. Pulin is being then Sunil Shodhar.
Sunil Shodhar. Which one? The third one.
Yes, my lord. Third one. Yes, my lord.
So second and third.
Third.
4652.
Ah. 4653. 4653.
Which page? Learned counsel 4652.
Yes, my lord, page 14, my lord. 4652, page 14.
Page 14.
Yes, my lord, delivery confirmed. On 5/2/2024.
Item delivered addressee.
Yes.
That is Sunil.
Yes, my lord. 666.
Madan Sardar.
Madan Sardar, my lord. This is Madan Sardar. This delivery is
4652.
yes, my lord. And thereafter 6664666, page 15. Next page, my lord.
4666.
Yes.
Page
15. Next
15.
page.
Item delivered addressee.
Delivery confirmed. For all the respondents, my lord, delivery confirmed.
Sorry. Now, in respect of, you are representing 5.
5.
Nishikanto.
Five.
6.
5, 6, my lord. So far, he is the son of Subal Chandra Sardar, my lord, brother of the respondent opposite party, on whom behalf I am appearing for your lordship. I have to check the Okalatnama. If their name appears there, then I will appear on it.
When will you check, Learned Counsel?
Otherwise, my lord, the whole thing appears.
Court is to ascertain as regards to the representation.
Subsequent application for affidavit.
The matter will be taken up at 2 p.m. In the meantime, you go through the file and apprise the court as regards to representation of the respondents. এটা দুটোর সময় আমাদের দিয়ে দেবেন, আমরা দেখে নেবেন।
দেখেন।
Vishwanath service.
আচ্ছা, ওই কবিবাবু এইটা বাদ দিয়ে সবকটা টু বি anything
Supplementary affidavit, my lord,
respondents.
last occasion, my lord,
Is it?
some defects were pointed out.
I'm not asking about that. As regards to the application, anything to be said?
No,
How many days delay?
11 days.
11 days. And that too, my lord, due to the fault of the learned advocate of the appellant, my lord. It's our fault, my lord.
Changed brief or? So you're bold enough to admit.
Well, it's true that should be taken into consideration.
आगे change.
This is change brief, my lord.
That's why you have been instructed.
My.
Copy served.
My.
Yes, ma'am.
Well, affidavit of service has been filed.
No, affidavit of- Have you gone through the application?
Well,
Hmm? Third line under the heading in the matter of Prabhu.
my lord, I am looking at can 5, my lord.
No. Can 6, third line under the heading in the matter of.
Wonderful. Okay.
Can 6. On donation of
Oh, delay. In my copies, it is right, my lord. Some way.
original it is not right. How can it?
Can 6 or the supplementary affidavit? Oh, supplementary. It's a supplementary affidavit. In the supplementary affidavit, it had gone down wrongly. But in the main application, it's correct.
Application for substitution of some certain-
Oh, it is.
Abatement and death of soul. What to be done, Leonard Council? What to be done? Hello. Clean. So can 5, can 6 and can 5 are being allowed.
Can 5 and 6.
Leonard Council, why supplementary?
Supplementary, my lord, in the cost title, my lord, correct names of the heirs were stated. But my lord, in the affidavit portion,
In the
my
earlier one.
lord, they indicated that.
Without substitution, the names have already been stated.
No, my lord, in the names, my lord, in the paragraphs, my lord, the name of the heirs of the respondents were stated instead of, my lord, the appellant. But in the cost
paragraph
title, my lord, the names were correctly stated, my lord.
The Learned Council representing the appellant files an affidavit of service let the said affidavit of service be kept with the record. Affidavit of service in respect of Can 5 of 2023 and Can 6 of 2023. Let the affidavit of service be kept with the record. Can 5, Can 6 of 2023 and Can 5 of 2023. দুটো একই লাইনে লিখবেন ঠিক আছে কলার আন্ডারলাইন করে দেবেন both the applications are taken up. Can 6 of 2023 being an application under section 5 of the Limitation Act 1963 praying for condonation of delay in filing the application for substitution upon setting aside abatement the death of the sole appellant Jamshed Jamshed Ali Saha Can 5 Can 5 of 2023 is an application praying for substitution of the sole appellant of the said sole appellant. Aforesaid sole appellant. Supplementary affidavit provision. Can 5 the supplementary affidavit. In respect of an application for substitution upon setting aside abatement. Full stop. Heard the learned counsels representing the petitioners seeking substitution, and the learned counsel representing the respondents. Full stop. I find sufficient cause shown in condoning the delay. As such, the prayer for condonation of delay is allowed. Can 6 of 2023. Hence, Can 6 of 2023 is allowed. As regards to Can 5 of 2023, that is the supplementary affidavit on behalf of the appellants seeking substitution of the legal heirs of the sole appellant. Let the legal heirs how many in number? 10. Let the 10 substituted. Let the 10 legal heirs of the said Jamshed Ali Shah be substituted.
As mentioned in para 4 of the supplementary affidavit.
As mentioned in paragraph 4 of the supplementary affidavit. Full stop. Follow. As such, Can 5 of 2023 is also allowed. Department is directed to take necessary step in this regard. There is another application being Can 4 of 2019.
That is to be heard along with the appeal, my lord. Because
Seeking,
my lord, they have got some loan from the Indira Awas Yojana. My lord, they have
suit for
declaration and injunction, my lord. In that suit, my lord, my title has been found by both the courts below. But due to certain technical defects, my lord, my prayer has been turned down. My lord, now, my lord, there is an injunction, appeal has been admitted. There is an order of injunction, status quo. My lord, in the meantime, they have obtained certain loans from the government authorities, my lord. They have prayed.
Who are they? No, they are in possession.
No, my lord. Possession is with me.
With you.
My lord, now they seek to overcome the order of injunction by saying that the injunction be vacated and they may be allowed to make construction, my lord. That was moved before the other bench, my lord. The other bench did not pass any order, my lord. Subsequently, they were the appellant died. My lord, now this application. Well, let that application be heard along with the appeal. My lord, if they win, my lord, they will get it.
My lord, copy of the Can application number 4. I have not served my.
You have not served.
No,
You have not served.
Can application
Learned counsel.
4.
Learned counsel. You have not served the said application.
That application I have not served mine. And application number 4 mine.
Yes, that's the sole application pending.
Only this application is pending.
Let matter would be.
This is of 2019. You have not received the copy of the said application.
But he is not eager to move, my lord. Let there be an order that it will be heard along with the application.
In the meantime, application, can application for will be submitted.
Is the said application in the record? Let us find out.
Find out. And mind kindly.
Is it the duty of the court?
No mind.
Report দিয়েছে কি?
আমরা তো একটা অ্যাপ্লিকেশন করেছি ব্যাটিং অ্যাপ্লিকেশন ব্যাটিং অ্যাপ্লিকেশন ফাইল করেছিল ওইটা তো ফোন না ব্যাটিং অ্যাপ্লিকেশন তো রিভিউ করেছিলাম
Can 6 of 2023 or can 5 of 2023 দুটোই dispose of হলো ঠিক আছে হ্যাঁ allowed
Sure, withdraw business. Consider heartless provider.
Yes.
Matter. Let matter would be hard.
Yes, it is in the file. An application for vacating the order dated 11/5/2017.
That was filed myself, my lord. And subsequently we withdraw this.
Subsequently,
we withdraw this application, vacating application.
As such, there is no order.
Order.
Correction.
My
withdrawn.
lord, I have gone through the entire.
Right order dated. Henceforth, learned counsel,
Yes, my lord.
be kind enough to
Yes,
go
my
through
lord.
the record
Excuse me.
prior to submission.
Yes, my lord.
তাহলে নেই না জেনে বলবেন কেন না জেনে বলাটা তো খারাপ হয়ে যাচ্ছে মেটার উঠবে এটা বলো
My lord, can you pass over? In between time, we check the
In the server, my lord, I have checked personally. Server, there is no such order about withdrawing that application.
No, that's why it is reflecting in the cause list.
Fine.
Yes.
Then let the matter appear on when under the heading application. Let it be under the heading application. On that day, it will be seen whether that is required to be taken up or not.
Day after tomorrow?
Day after tomorrow.
Yes. In between time,
প্রবীর এই
In between
সাবস্টিটিউশন
time,
হয়েছে সাবস্টিটিউশন পাঠাতে হবে
in time, my lord, I check the file, man. In between time, I
Yes.
inspect the file.
have an inspection of the file. Let the matter appear on 28th of February under the heading application. It is being placed under the heading application. Let us see.
Can number 4.
Let-
এটা তো ডিসপোজ অফ
Next. That part heard matter, no? You have to give the reply.
But in this matter, but I am for the respondent, but this is, but
23, item number.
this is my application for dispensary of respondent number 2. But your lordship, kindly see that the order,
There are several applications pending. Learned
no,
counsel.
all application,
All are?
Sir,
application has been disposed. Your lordship kindly see order dated 24th March 2022.
Who is, you are representing the respondent?
Respondent. Only respondent.
No, there are more than one respondent.
Yes, that is why, Lord, I am filing this application, especially service of respondent
Respondent
number
number 2. Has
Your
become-
Lordship, kindly see the order dated 24th.
Who is representing the appellant?
But on the last occasion, they appeared now. Today, only your Lordship kindly. Then I will.
Oishik Chatterjee had appeared on
Yes,
behalf of
Kusal
the.
Chatterjee.
No, it is in the order sheet. It is mentioned Oishik Chatterjee.
Oh, last year we should last.
Might be the same.
Yes. Order Lordship kindly see the 24th March 2022 passed by Justice Vishwajit Bhatt.
Dispense with service the respondent. And, respondent number 2 is Gopal Chandra Dotto.
Yes.
Can 2086 of 2019. Application for dispensing with the service upon the respondent number 2, Gopal Chandra Dotto.
Yes.
Order dated?
Order dated 24th March 2022. Practically last order.
Hmm. 2086. Mr. Kushal Chatterjee. Yes, on that day, Mr. Kushal Chatterjee had represented.
Yes. The order is
appellant.
not, your Lordship
Affidavit
kindly
of
see, this
service
is an
of
application filed by the respondent number 1 for dispensary service of notice of the present appeal upon the respondent number 2.
Cannot be considered.
The prayer of the respondent number 1 cannot be considered at this stage as no attempt has yet been made to effect such service. The appellant therefore is directed to put in requisite for service of notice of appeal upon the respondent number 2 by speed post with acknowledgement due within a week from date. The office report dated March 10, 2022 suggests that the lower court record has reached to this court and on inspection it has been found complete. The appellant is directed to prepare requisite number of paper books without certificate within 2 weeks from the date of a copy whereof shall be supplied with Mr. Kathakar.
So,
now, my dear Lordship, kindly see the administrative order dated 26 April 2023. 26th April. Have you got it?
Yes.
Mr. Debru Chaudhary, Latent Advocate, appears for the sole appellant, peruse the office report dated Atho and the Honorable Court's order dated Atho. In the said order, the appellant was directed by the Honorable Court to put in requisite for service of notice of appeal upon the respondent number 2 by speed post with acknowledgement due within a week from date. It appears for the said office report that no steps has yet been taken by the appellant for causing service of notice of appeal upon the respondent number 2 by speed post. In view of the aforesaid, the matter be placed before the honorable bench with a comprehensive report for appropriate order. Lordship, my prayer is, Lordship, kindly make it default clause so that they have to take steps.
Had the respondent number 2 represented before the trial court and the first appellate court?
No, they have not. That is
Inspector,
why I filed this application. They have not filed paper book also.
none is
They have not
representing-
filed paper books. Your Lordship has seen this court.
None is representing the appellant.
On the last occasion they appeared. But that is why I want to submit before Lordship that Lordship kindly make it a default clause so that they have to not take steps and they have to file paper. Even then they have not appeared before this court. Because your Lordship has seen 26 April 2023, the
Learned Counsel will be kind enough to intimate the Learned Counsel representing the
last occasion I intimate, last occasion they appear. and took time before your lordship. Only to show your lordship the order that no, they will not prejudice because not I will intimate that after passing your lordship's order, default clause. Nothing I want. Let it be default clause, 2 weeks, 3 weeks, and paper book they will file, they will not take steps, then the matter will come.
From the order sheet, it is revealing that the appellants are not interested to proceed with the instant appeal.
That is another thing, Lord. Lordship can make it default clause. If they do not submit, file, then the appeal will be dismissed. Then they will take steps. Because it is your Lordship has seen this court passed this order, administrative order is there.
Lord Senior Counsel.
Yes.
Let the matter be fixed tomorrow.
Tomorrow?
Tomorrow. In the meantime, be kind enough to intimate the other side that the matter will be taken up tomorrow. Positive. I'm making it not today. I'm not passing any order. If nobody represents the appellants, then tomorrow the order will be passed. Because
let it come tomorrow.
The matter will appear tomorrow. In the meantime, you intimate the learned counsel. এটা নোট করে থাকছে কালকে থাকবে tomorrow necessary order will be passed.
Great.
If they are absent. Next.
Item number 27.
My lord, I am for the appellant petitioner, my lord. My lord, there is an application for condonation of delay, my lord, of
Section 5 application.
Section 5 application, my lord. My lord, on the last occasion, it was my lord, can 9585 of 2018.
New number can 1 of 2018.
My lord.
And what about can 2 of 2018?
That is, my lord, stay application, my lord. Okay, my lord. Yes, my lord. That is a stay application from creating the third party interest, my lord.
So now only the Section 5 application can be taken up.
My lord.
Apart from that, no other application.
My lord.
Thereafter,
The only
also, how many days delay?
my lord, 80 days delay, my lord.
80.
80.
Wrong calculation has been made, my lord. This is not, my lord, 80 days.
My lord, total 170 days, but my lord, after exhausting the period of filing of second appeal, my lord, that is 90 days, my lord. That, for that reason, my lord, 80 days delay is there, my lord.
Cause?
My lord, I have stated the cause in
Paragraph.
paragraph number 8 and paragraph number 9, my lord. The judgment and decree come on, my lord, 27th March of 2018, my lord. But after that, my lord, there was a vacation, summer vacation from 21st May 2018 to 2nd June 2018.
Judgment Was dated 27th of
March 2018, my lord.
18.
At that point of time, my lord, I got unable to, my lord, apply for the certified copy. But after summer vacation on 31st of May, my lord, 2018, I have, my lord, applied for the certified copy, my lord.
Learned counsel.
My lord, first of all, my lord, the calculation of days is, my lord, not 80 days. And my lord, there are, my lord, there was, my lord, or there is, my lord, or there are, my lord, 1 to 5. 5 petitioner, plaintiffs, appellant there. And, my lord, point is this, my lord, he was unable. Petitioner number 4 is unable or seriously. But other, my lord, 4%. Not taking about this ground that they are also ill and they could not affirm the affidavit. So this is not satisfied ground.
The petitioner number 4, my lord, was the conducting person before the learned trial court below, my lord. He was having the full responsibility, my lord, to file this second appeal on behalf of the other petitioners, my lord. For that reason only, my lord. He was actually ill, my lord. I have annexed the doctor certificate.
Would you like to file affidavit in opposition?
Of course, my lord. Otherwise, my lord.
Mean. Let us check item number 27. The learned counsel representing the appellants and the learned counsel representing the respondent present. Full stop. The learned counsel representing the respondent submits that that he would like to file an affidavit in opposition in respect of the said application, praying for continuation of delay. That the affidavit in opposition be filed within
2 weeks.
Within 2 weeks. Reply, if any, within
1 week, ma'am.
Within 1 week thereafter. Let the matter appear after 4 weeks.
Great.
Yeah.
For this one.
Next. Another application. It is the section 5.
What is one?
Number 28.
28 plus 9.
Also, I am for the respondent also. Two applications are pending.
Application lawsuit for stay. Initially, lawsuit the Honorable Justice and Supersede Dasgupta Diden was pleased to pass the stay order. Kindly lawsuit the application for extension of interim order.
How many applications are pending, Learned Counsel?
Only one lawsuit. Can number earlier name can number 8632 of 2017. New number 1.
The matter will be taken also. Can 1 of 2017 is stay?
Stay.
Can 3 and 4 have been disposed of? Being allowed. Restored to its original file and number. 3 and 4. Nil.
Lordship, one indulgence, only one submission, Lordship. Lordship, regarding this stay application, Lordship, one submission.
As of now, I have not taken up the application trying for stay.
Lordship, I'm sorry, Lordship.
There's anomaly in the last order.
Lordship,
On going through the order sheet, it reveals that that the applications being Can 3 of 2023 and Can 4 of 2023 have been both had been allowed allowed and disposed of by order dated 6/10/2023. So 4 of 2023, 3 and 4 but disposed of. As regards to Can 2 of 2022.
An application for extension of interim order, Lordship.
Achha. Staying execution of decree staying execution of the none is representing the school to the Learned Council appearing on behalf of the appellant is requested to intimate the Learned Council appearing on behalf of the respondent. The matter will be taken on extension. And now, as regards to Can 1 of 2017.
Can 1 of 2017 and
There's
application
interim
for
order.
stay.
There's interim order of stay.
Stay. Interim order of stay, Lordship.
Wide order dated
Order dated, Lordship. The order
13/12
dated
2018.
2018.
Old number 8632.
Code number 8632 of 2017.
The application for injunction restraining the plaintiff decree holder respondent from putting the decree in execution till the finality of the instant appeal. It is submitted by senior advocate appearing with the appellant that a caveat was known to Mr. Hon'ble, but he refused to accept the copy of the injunction application. In view of the appellants are directed to serve a copy of the injunction application upon the respondent. In view of the above, the appellants are directed to serve a copy of the injunction application upon the respondent by speed post and shall file affidavit of service on the returnable date. The plaintiff decree holder respondent is restrained from putting the decree. The plaintiff decree holder respondent is restrained from putting the decree dated 22nd December 2004. No. আপনি নিচ্ছেন নাকি? অর্ডার পাস হয়নি এখনো, দাঁড়ান কিছু বলিনি, এটা পড়ছি। The plaintiff decree holder respondent is restrained from putting the decree dated 22nd December 2014 passed in title suit by the Learned Civil Judge Junior Division in execution for a period of 8 weeks from date or until further orders of this court, whichever is earlier. Liberty is granted to the respondent to pray for vacation, variation and or modification of the interim order before the appropriate bench. You have received the copy of the application?
Yes, Lordship.
So, any affidavit in opposition?
Lordship, I am praying for allow me to file an opposition, Lordship, because at this stage, Lordship, it will reverse our rights. We are the decree holder.
But the Lordship, the execution case is going on already fully allowed, Lordship.
What to be done?
And Lordship, limited stay, limited period. In the meantime, the appellant filed the paper.
So it will reverse our rights, Lordship. At this stage, Lordship, at final disposal of
2019, you had the opportunity, ample opportunity.
At that time, no amendment was made, Lordship.
The Learned Council representing the 1 week Learned Council.
Lordship, Lordship, kindly grant 2 weeks, Lordship. Or other matters, Lordship, kindly grant 2 weeks.
Execution is pending and to be executed. The Learned Council representing the
Lordship, one is
appellant praise for
And Lordship, in the meantime, allow the stay.
no Learned Council. the learned counsel representing the respondent submits that he intends to file affidavit in opposition in respect of the application praying for stay. Consider the prayer of the learned counsel. The affidavit in opposition be filed within a week, and reply if any within within 1 week thereafter.
So they allow the stay next day.
No, learned counsel. The matter will appear on 26th, 11th of March. Lordship, I'm grateful. Under the heading application. Under the heading application. Lordship, I'm grateful. Next.
I'm for the petitioner.
Lord, I am for the respondent number 1 to 13, except my lord 5C.
1 to 13.
13, 1, 3, 13. Except 5C.
Can
Except 5C.
Can 2 application for injunction
My lord,
and 3 application for substitution.
What about the respondent number 5C?
Respondent number 5 died. Substitution application has been filed.
He or she?
He.
Haradhan, he has been substituted.
Substitution application has been filed. Can number 3, which is pending.
Which is pending.
Can number 3. Application has been filed in time on the date of respondent number 5 and 8.
Can 3 of 2023?
Yes, ma'am. I see.
It's late.
Just late.
How many respondents have expired?
2 respondents, 5 and 8.
5 Haradhan late and respondent number 8 Vijay Kumar Laha.
Yeah. Application has been filed in time, within 90 days.
When 5 has expired? 10/10/2023.
10th October 2023
and
5 expired and 8 expired on 13th August 2023. Application filed 18th October 2023.
Five, the legal heirs are in paragraph number 2.
Yes.
5A, 5B, 5C, 5D.
5D.
And the legal heirs of 8 are in paragraph
Top
number
three.
3. 8A, 8B,
8C.
8C. Apart from these legal heirs, no other legal heirs there.
No.
Don't it, counsel?
And my lord, earlier occasion, my lord was pleased to direct me to file the affidavit in opposition in regard to
Injunction application.
can 2. My lord, I have affirmed and served them. May I file?
Step by step. Let me dispose of the can 3. Nin. Can 3 of 2023 is an application praying for substitution of the respondent number Haradhan late, Haradhan LET late, and who is the respondent number 5, and Bijoy Kumar Laha, who was the the respondent number 8. The said application has been filed within the statutory period. Heard the learned counsels. The said application being filed within the statutory period is allowed. Being filed within the statutory period is allowed. Let the legal heirs as mentioned in paragraphs 2 and 3 of the said application be substituted in place of the deceased respondents number 5 and 8 respectively. Department to do the needful. Department to bold kore deben. Department to do the needful. Full stop. Now you file the affidavit of service.
Affidavit in opposition.
Affidavit of opposition.
In respect of
can-
can number 2.
Reply.
And my lord, kindly fix any date for can 2.
Injunction application.
There is an application being in the paragraph. There is an application being can 2 of 2022 praying for an order of temporary injunction restraining the principal opposite parties from encumber the suit property.
No, beach.
Suit is of? Suit is for?
Suit for declaration of title and permanent injunction.
Permanent injunction.
Shall court
Otherwise
dispute regarding title.
Otherwise the instant appeal is ready for hearing.
I am ready.
Apart from the
application.
No,
Can
not
do-
the application. Instant appeal I am saying.
Instant appeal paper book has not been filed lower court.
LCR? Not
LCR
yet
has
received.
called for, but whether
Not
the
yet received.
LCR has come or not.
LCR আছে এখানে? LCR নেই। তাহলে last line টা কি? Last line টা? কি লিখেছে? From changing the nature and character of the suit
My lord,
property
kindly do not hear.
in any manner whatsoever. In this regard, affidavit in opposition has been filed on behalf of the respondents number 6, 4 to 6 CHA and 7 to 13. Affidavit in reply has also been filed on behalf of the petitioner, appellant petitioner. Let the matter be fixed on.
My lord, ad interim order of
No, my lord,
For the
kindly hear
interim order.
today. No, not today. Can do.
When?
Next week.
5th of March, Tuesday week, 5th of March.
My lord, in the meantime, if the suit property is being encumbered,
Counsel,
Then in this week, but kindly do not hear today. Can do.
you undertake that no changing of nature and character will be taking place.
My lord, kindly fix it tomorrow. Tomorrow, my lord.
Tomorrow. The tomorrow.
Therefore, no
day after
undertaking.
tomorrow. One day after tomorrow can be fixed.
After modification চলে আসবে তো rectification এর পর substitution হলো চলে আসবে তো ডিপার্টমেন্ট থেকে on 28th of February under the hearing application for hearing of the Can 2 of 2022. Next.
I execute on behalf of the appellant. By last order dated 1st of February 2014, my lord have directed the department to file a report I regard to the filing of wakalatnama on behalf of the sole respondents with the Mukherjee. My lord's order 1st February 2014.
Hon'ble Bennett Council is present, submits that he has filed Bhattacharya on in the month of July 2023. Is not in the file. The department is added to file a report as regards the filing of Bhattacharya 2014. That the matter fixed. On behalf of the respondent number 1. Yes, learned counsel.
Lordship.
Wakalatnama has been filed on 30th January 2024.
Lordship. By not by Ivan Roy, Mr. Leonard Counsel. But
So why have you not gone through the file?
I have gone through, I have raised objection. He submitted that he have filed.
You have gone through the file?
With the leave of the court, my lord, I have gone through in the month of January. No,
Today-
now I have
today-
not. No.
It has been filed by learned advocate Nirupam Dotto and Ivan Roy.
Lordship. On the 30th of
30th of January 2024.
and the sole respondent have died on the 7th of April 2023, my lord.
Lordship.
So after death of the sole respondent, how the wakalatnama can be executed by the sole respondent, my lord.
May I be permitted to submit, my lord?
1 minute. First of all, sole respondent or there are
Sole respondent, lordship, sole respondent.
That can be seen from the impugned judgment, my lord.
Acha.
My mistake.
Oh, the Sri Mataji Ashram.
That was the second residential address of the sole respondent.
Lordship, if your lordship kindly go through the earlier order of this honorable court. My lord, in the month of July 2023, I have informed this honorable court regarding the filing of my Vokalatam and regarding the death of the sole respondent. I have informed this this honorable court. My lord, my Vokalatam, I have submitted the Vokalatam in 16th of March 2023, prior to death. What happened, my lord? This Vokalatam, my lord, due to the lack of some information, this Vokalatam has not been filed. And learn this.
First of all, you submit the exact term which you intend to submit.
Lordship.
When have you filed the Vakalatnama? When have you filed the Vakalatnama?
My lord, this Vokalattama has filed on 30th of January. I followed, lordship. But how did I come to know that this Vokalattama has not been filed? My lord will kindly see the Vokalattama at once. Kindly see the Vokalattama at once, my lord. Information, lack of information, this Vokalattama was kept in the department. After your lordship has been directed me to get to know whether the Vokalattama is filed or not. I sent my clerk to know the whereabouts of the Vokalattama, whether it has been filed or not. Then I came to learn that there no phone number and bar number has not been mentioned in the Vokalattama, for which it cannot be filed. It was kept in the my lord will also, my lord, kindly see, my lord, I have informed this honorable court on month of July, that the petitioner has
your name?
My lord, my name is Ivan Roy.
Ivan Roy. Learned Counsel, Mr. IVAN, Ivan Roy, submits that he had filed the Vakalatnama on representing Shuchita, S-U-C-H-E-T-A, Shuchita Mukherjee, in the department on
March 16th.
On 16th
March 2023.
On 16th of March 2023. Full stop. The report. Hey, Provido. Department dated 7/2/2024 reflects that the Vakalatnama on behalf of the respondent number one. I'm going through the report. What has been mentioned in the report on behalf of the respondent number one had been filed on 30/1/2024. Paragraph. Thus, there is discrepancy as regards to the submission of the learned counsel and the order and the report and the report filed by the department. Full stop. The department, paragraph, the department is directed to file a report vividly stating the entire facts, date, and if any other necessary instructions which were there in respect to the said wakalatnama. Wide and by a report by by department 29th of February. The department is to file the report bearing the seal of the person who is furnishing the report. Let the matter be taken up on 4th of March.
As it was choices.
Nowadays, the wakalatnama is reflected in the course of the day, my lord. It should be filed, my lord. And in this case, my lord, the sole respondent have filed no substitution application has been preferred by my learned friend, my lord. So it is many, it will not good to allow to run these disputes for weeks and weeks, my lord.
So what to be done?
My lord, after this report, my lord, if they are not
we know.
Let's
Item number 17.
Well, Mr. Roth is not here. Your Lordship asked him to come. So,
Sorry to commit mistake on my part, my lord. I am appearing for opposite party number 1, 2, 3, 5, 7, 8.
only 4.
And file Dokatulama 1, 2, 3, 5, 7, 8. Of the respondents opposite parties.
4. 4 I have solved, my lord. Yes, my lord. This affidavit of service, page 6, my lord. Second one, Madan Sardar. 4. Item delivered, my lord. Your Lordship. That is in 14, perhaps. Page 14. Yes, my lord. Page 14. Page 14, my lord. Vishwanath. My lord. Vishwanath Sardar, my lord. 14, my lord. Right hand side corner, delivery confirmed. And Vishwanath Sardar, my lord, page 5, receipt is respondent number 6. Page 5, my lord, the receipt, last receipt. Amongst the 6, last receipt, my lord, 4635. Before that, 4635. 4635. My lord, page 12. It is also delivered on 5th February 2024. My lord, right hand side corner, top.
My lord.
7.
My lord.
8 and 9 also delivered, my lord.
1, 2, 3, 5, 7, 8.
7, 8. 8. 9, my lord, that is Bimola Bala Sardar, who died, my lord. And for her, second can number 2 was filed. Kindly have a look into that. Can number 2, substitution, my lord, substitution. My lord, in this, my lord, can number 2. Both the application were
representing the respondents number 1, 2, 3, 5,
7 and 8.
7 and 8 is present. Affidavit of service has been filed in respect. Affidavit of service has been filed on behalf of the appellant, from which it reveals that the notice has been served upon the respondent number 4 and 6. 4 and 6.
And 9 also, my lord. Your lordship asked me to serve.
1 minute.
Both applications served.
4 and 6, but none is representing. The respondents number 4 and 6. Let the affidavit of service be kept to the record. Full stop. Next. এবার হচ্ছে,
9.
The learned counsel representing the appellant submits that the respondent number 9, namely Bimola Shodhar, has expired on
My lord, 4th January 2020. 14th January 2020. Can 2, my lord.
Can 2.
Both the matter, my lord, I have subbed together as per your lordship's direction.
No appeal.
My lord, kindly have a look into the cause title, page 3.
Within time?
Yes, my lord. No, my lord, not. It is not within time, my lord. Limitation, my lord, I have. Application for, my lord, kindly have a look into cause title. Application with an alternative prayer for substitution of legal representative of respondents Bimola Bala Shodhar by setting aside the abatement after condonation of delay. My lord, this is 1 to respondent number 9.
When Bimola
died on 14th January 2020.
14th
January 2020.
After that, appeal has been preferred. After death of respondent number 9, opposite party number 9.
But some of the respondents, some of the persons of the representatives were already made record in the appeal. 1 to 8, my lord, they are already in record.
How could you?
My lord, that was, they have, along with them, they have preferred this plaint. That is why. With mother.
14th January 2020, death is there.
My lord, kindly have a
Respondent number 9.
14th
Yes.
January 2020, Bimola
Death
Shodhar,
occurred. Paragraph
expired.
2.
And the instant application has been filed on
my lord, 2023.
2023.
23.
When the first appellate court passed the judgment, first
Death
appellate court,
certificate.
First application, my lord.
first appellate court passed the judgment.
Page 29, death certificate.
First appellate court passed the judgment.
When the first appellate court passed the judgment.
In the year 2018, my lord.
So at the time she was alive.
Yes. At that
Thereafter
point
she
of time.
has expired.
Subsequently, when I have served the copy,
Learned counsel,
but kindly have a look into page 4 of the page 4 of the application number 2, my lord.
Page 4.
4, my lord, the cost title. My lord, here, my lord, kindly, my lord, with can number 1, my lord, Sri Nishikanto Shodhar, Sri Vishwanath Shodhar, D2J. My lord, they are already made party in the appeal because they were already on record.
They are already on record. Nishikanto D2J.
Yes, my lord.
Who are not on record?
Anil Shodhar, Pulin Shodhar,
Who are not on record?
1A, B, and C. They were served. That is their daughters, perhaps.
Kajol Manna, Purnima Singh, and Madhavi Pramani. Learned counsel.
Are you appearing?
Paragraph 2 of the application, my lord. It, my lord, reveals that paragraph 2 of the application, number 2, page number 6. Death of respondent number 9, Bimola Shodhar. She died on 14th January 2020. And the appeal has been preferred in the year 2022. My lord, the substitution, my lord, in case of, my lord, the
what do you intend?
Dead person maybe.
What do you intend?
My lord?
What do you intend to do?
22. No.
Am I not clear? Am I not audible? Am I audible or not?
My lord, The person concerned, my lord, she died on my lord, on 22nd, 2022. And my lord, the application which has been made, my lord, subsequently. They let the application for addition of party is there. And my lord, I am appearing on behalf of respondent number, my lord, 1, 2, 3, 5, 7, and 8.
That is.
And my lord, the application for condonation of section 5 application, my lord, many things have been suppressed there. The real things have not been, my lord, disclosed there. I want to, my lord, file the, my lord, opposition to that. Even that after that you submit. And 1,308 days delay.
Yes, my lord. Within that, my lord, that COVID period is also there.
And no cogent reasons have been.
1308.
No further submission. So can who is pending and can one.
Can one.
Section 5. There's another application.
Can 1 and 2.
Can my lord 1 and 2.
There's an application,
application.
praying for addition of parties.
Addition of party in the same prayer, same application, my lord.
Addition of party application can 2.
Can 2, my lord. And automatically they will be added.
No. They will be substituted or added.
My lord, substitution, my lord, for 3 persons, my lord, substitution will be there. And after substitution, my lord, they will be added as party. Subject to your lordship's correction, my lord.
The learned counsel representing the respondents submits that he intends to representing the respondents. Submits that he intends to file an affidavit in opposition to the said application, being can 1 of 2022 and can 2 of 2023.
3.
Within, my lord, within
কতদিনের মধ্যে করতে চাইছে?
within 2 weeks, within 2 weeks from this date, and reply if any within 1 week thereafter. Let the matter appear after 4 weeks under the hearing application.
Just a few minutes back,
affidavit of service be kept with the record.
I am facing troubles of hearing just a few minutes back. I don't know what is the cause, my lord, there.
Then, my lord, I am appearing for the petition. My lord, as per your lordship direction.
Nobody is representing the respondents.
No. My lord, today is the date fixed. My lord,
What is the date fixed for?
Execution proceeding.
No, it cannot be.
My lord.
Generally, hearings are taken up on Saturdays.
This is the lower court's record, my lord.
Nobody is representing the respondent.
My lord, my application for stay is there. And my appeal has been admitted by the division bench, my lord. My lord, last portion, my lord, title execution case 10. Previously was on 29. I told him to make a photograph of that date also. He has given the same.
Display হচ্ছে না?
My lord, it was filed in 2018. My lord, as the matter has not been admitted, I had not been able to serve the copy. My lord, the matter has been admitted in 23. I have served the copy. My lord, if there be no stay order, my lord, the execution will be processed. My lord, kindly consider that. My lord, my lord, kindly consider one thing. My lord, they have filed the execution proceeding. In execution proceeding, they have filed the police application. And today was the date fixed for hearing of that application. First appellate court, my lord. 29th January 2018. And it was confirmed the judgment degree passed on 21st 21/6/2014. My lord, I have served. They have the address given by them. I have served on that address. My lord, that was returned back. Address that was given by. Where should I then serve? My lord, then kindly direct me to publishing in the newspaper. My lord, sir, twice I have served. This is as per your lordship direction. I have served the second time also. My lord, the earlier one is on. There is the affidavit service also with regard to that. My lord, previously on 17 January 24. My lord, that was also returned. There is a previously there was another affidavit of service, my lord. That was also returned. Address. I have made the rectification and serve now. Appropriate. My lord, in this time also I served twice. My lord, kindly go through the record. I have served twice. Again. My lord, first on 29 January and next on the 21 January I served twice, my lord, on self-same address. Both have been returned back. Both returned back. Thereafter I serve on the learned advocate. On the same person, Babul Haldar, I served twice. Sarkar, my lord, I'm praying for apology. Sarkar. I served him twice. Both are returned back. If there is an address, there should have been someone. My lord, kindly once, my lord, kindly go through the judgment of the lower court, my lord. The judgment, I corrected the memo, my lord, as per the judgment. And there is no other. Execution application, my lord. Plaintiff copy আছে my lord, once my lord kindly go through the plaint. This address has been given in the plaint also. Corrected one, and I have served also that address. My lord, the learned advocate representing them in the learned court will at the execution proceeding. My lord, kindly go through the record, affidavit of service. Mr. Sam Prasad Rai, learned advocate. He has received the same, my lord. This is the first instance. I have no knowledge. My lord, as per the judgment. No, my lord. He was the person representing previously also. My lord, kindly come to the judgment of the appeal court. His name is recorded, my lord. Shankar Prasad. My lord. My lord. Kindly come to the judgment portion, my lord. Malda. Here, no one appear over here. No one appear. Ten of 2014, 2018, 10 of 2018. 2018, well, maybe. My lord, may I permitted to open the record, my lord, in phone, my lord. Ten 2014, my lord. 2014, my lord, on 26/2/2024 record, my lord, from the lower portion, third, from the last three. Thereafter, 10 of 2014. My lord, this is on today, 26. And my lord, on previously on 29th, my lord. 29, my lord. My lord. My lord, on 29, my lord, kindly come to 20, just previous page. My lord. My lord, they want to cancel our deed without any without making any prayer with regard to the same. Only for declaration. My lord, they want to cancel a deed executed by them, but they have not make any prayer with regard to the same. They only pray declaration and for declaration that they are the owner of the property and for khas possession. My lord, the person, my lord, kindly go through once, my lord, kindly go through the. I have given your lordship the list of dates, my lord. My lord, there are show. My lord, the second page, my lord. Hey, what that mean? এটা দু পাতার হবে দিয়া আছে স্যার এই মাত্র দিয়ে my lord second page my lord the first property was of Supratim Rani Saha. Thereafter he sold the total property to Rasmani Sarkar. He sold the property a part schedule property to Babul Sarkar. My lord, this Babul Sarkar sold the property. Thereafter third person, I have purchased the property from Dhirendranath Das. If they want to cancel the deed, they should have to cancel all the deeds. They have not cancelled their own deed. They have, and that has not been also marked as exhibit. I think, my lord, for police help. My lord, I am in possession. I'm in possession. My lord, as they have not. My lord. My lord, they have not prayed the cancellation of a deed. My lord, kindly consider what they have prayed. They have prayed for declaration and for khas possession. Their suit is not cancellation of a deed, though they have make a deed in my favor. If the deed has not been cancelled, then how the decree could have been passed with regard to declaration? Though both the learned court granted the decree with regard to the declaration. I came before this honorable court. This honorable court division bench has admitted my second appeal with regard to on this point. My lord, kindly consider the substantial portion of law. My lord,
a criminal court in a criminal proceeding is binding on the civil court in
My
absence
lord.
of any cogent evidence adduced by the party in support of the reliefs, whether the documents exhibited in the criminal proceeding and the findings returned thereupon would be presumed to be a part of the record in the civil proceeding and to treat such exhibits as sacrosanct in deciding the suit.
My lord, now what they have given in the what they have given in the criminal
Last
case.
time you served notice upon the respondents.
again, my lord, on the same service, same address, or I should have to my given in the newspaper.
Thereafter, the learned counsel representing the appellants submits that files an affidavit of service. Files an affidavit of service. From the affidavit of service, it reveals that the items could not be delivered upon the respondents. Unless the affidavit should be kept to the record. In such circumstance, the
My
learned
lord,
counsel.
I have given you the given your lordship the copy of the plain, my lord, that I have get. I should have to serve on that address again, because that address has been returned.
You have rectified the address.
I have rectified. As the address that has been given in the plain.
The address
that has been given in the plain. I serve on that. That is the record.
Whether the address which is mentioned in the plaint tally with the address which you have rectified.
My lord, kindly go through that.
I will trust you. I am trust.
I have
The
given
learned
on
counsel
that
is to be
address.
trusted.
Now I have given on that address.
Which address?
That was
Which is
telling in
revealing
the
which is revealing in the plaint. Yes.
That has returned back. That not found. Now what should I do? I again serve on that, or I should given through newspaper.
You serve once again for the last time. If the same thing reveals, then paper publication.
My lord, kindly consider. Then, my lord, kindly consider. Maybe they have not taken, or maybe there is some difficulty. But for this, the execution proceeding will have been good on. And my lord, they have filed the execution proceeding. They have filed the application under for police help. As the bailiff has not been taken the possession, so they have filed the application for police help.
For the last time, you serve notice. If it is not possible, if the same fate reveals, then paper publication will be, order of paper publication will be there.
My lord, kindly consider one thing also, my lord. If they have taken the possession, my appeal has become infructuous.
What were you doing in the meantime?
My lord, kindly consider
before in the interregnum period,
18, in
where were you
2018,
doing?
my lord,
In,
in 2018
from
I have filed.
2014 till
2018 I have filed. 2019 2020, COVID going on. My lord, thereafter I took up the matter for admission. My lord, unless that has been admitted, how could I serve?
You serve. If any adverse effect takes place against you, that will be reverted back.
My lord, again, if my possession would have been gone, then the appeal would have been become infructuous. I should have to file again an application under section 16 of the Pacific Relief Act.
What will happen? What will happen? That is not known to you also, not me. According to the circumstances, necessary step will be taken.
My lord, then kindly fix it next week.
To serve notice upon all the respondents through speed post with AD. Through speed post with AD. With returnable on 26 तारीख तो let the matter appear on 7th. Will it be possible? 7th.
And my lord, in the meanwhile, can my lord, I'm praying for a stay of the execution. If in between that police will go and my possession would have been taken, then this appeal become infructuous.
You couldn't serve even upon one respondent.
My lord,
counsel.
My lord,
if at least one respondent had appeared, then.
My lord, I have served as per the address they have given. It is not my address. as per the address they have given. And my lord, I have also served the person who is representing them in the learned court below.
Learned counsel, then in that situation, you bring the copy of the title execution.
My lord, only one day time, my lord, I will bring it day after tomorrow.
Day after tomorrow.
Day after tomorrow.
Let the matter appear on 28th.
My lord.
You bring the title execution. Copy of the title execution. 28th. Affidavit of service be kept to the record. Affidavit of service be kept to the record. File today be kept to the record. The learned counsel representing the appellant is directed to produce the copy of the title execution on 28th. The learned counsel admits that he will produce the copy of the title execution on 28th. Let the matter appear on 28th. Next. The question from this end is, what were you doing during this period?
My lord, unless the appeal has been admitted, my lord, kindly consider, unless the appeal has been admitted, I have no right to give him any copy.
That is true. That is true. But as regards to admission,
my lord, at the time of admission, the opposite party is not required.
This is not the fact. You have filed it in the year 2018.
My lord.
It has been admitted during the year 2023.
My lord, because in between the, my lord, kindly consider the period between that. The COVID situation is going on in between that.
On
My lord,
28th, on 28th, you bring the copy of the title execution along with the, what is the latest position?
My lord.
Bearing the details of the cross title. Next. Next.
I'm responding in this matter.
The appellant.
Yes, appellant, my lord. Two application is pending, my lord.
Can 1 of 2023?
Can 1 and can 2.
Can 2 of 2023?
Yes, my lord. Can 1 is, my lord, for condoning the delay in preferring the appeal, 35 days delay, my lord. My lord, in fact, can 2, my lord, during the pendency of this appeal, respondent number, one of the respondent died. Now, my lord, we have filed that application for substitution. There was some delay. That's why, my lord, we have filed that application after setting aside the appointment and on condoning the delay. This is the fact. Now, my lord,
Today I'm praying for you. Keep it the matter day after tomorrow because I'm not ready for today. Just time day after tomorrow.
The copy has been served upon you.
Obviously.
Long.
Directly I come from my home. Therefore, difficulty is this. I record with not with me. There is a difficulty.
This is not a reason, learned counsel.
Day after tomorrow. Keep it.
As per the prayer of the learned counsel, representing the prayer of the learned counsel, representing the respondents. You are representing all the respondents.
All the respondents.
Representing the respondents. Let the matter be fixed on 28th of February. Under the same heading. You have received the copy of all the applications?
Yes, my lord. My affidavit of service is also there. He is appearing and copy has already been served long back, man.
I'm sorry for it. I'm grateful.
Next.
কোনটা চাই জানতে চাইবেন
Please, your lordship, I appear on behalf of the appellant, in a suit for declaration.
Lord Counsel, yeah.
I, my lord, appear on behalf of the respondent number 1, 2, 3, 7, and 8. My lord, before my learned senior friend starts, my lord, I must be very candid. That I thought, my lord, a can 1 or can 2. Can 2 substitution application or leave to prefer an appeal. My lord,
Can 1 of 2023 is in respect of?
That is not an application seeking stay injunction.
1.
And 2 is not a misconceived application in the sense that one of the respondents died after the decree passed by the lower appellate court and before the appeal could be filed here. That application is couched as leave to appeal. It would simpliciter be, my lord, an application for substitution, for bringing on record the names of the heirs of the respondent number 4 who are already on record.
Who are already on record.
So only, my lord, to treat it on record, nothing more. So 2 is, my lord,
Formal order was required.
Yes, a formal order.
Is it so?
my lord, so far the application has been served upon me. My lord, I find the
leave to appeal.
Yes, leave to appeal.
It has been prepared.
Judgment and degree passed on, my lord, 17 November 2022.
As of today, the instant appeal has not been admitted.
Yes, has been admitted.
Has not been admitted.
Has been admitted.
Appeal admitted. Appeal admitted, my lord, perhaps on, if my lord sees the previous order.
My lord,
order?
My lord, with the order dated 5th of December.
The 5th of December 2023.
My lord.
Having 2 substantive questions of law.
Yes.
My lord, kindly peruse the.
Can 1 of 2023, can 2 of the appellants are to serve copy of the instant applications upon the respondents by speed post and shall file the affidavit of service. You have received the copy of the can 1 and can 2.
Yes, kindly see the.
In respect of the other respondents, learned counsel.
Yes.
My lord, I have, my lord, sent copies in terms of my lord's order. Then my lord again directed me on the 15th of January.
What is the fate now?
My lord, now, my lord, the stage is that since this is a judgment and decree of reversal, my lord, the judgment and order passed by the appellate court below, that is staring in my face. I am seeking for a stay of operation of that judgment and decree. My lord, lower court records be called for. And, my lord, let there be a direction for preparation of paper book upon verification of the records by the department of my lord's court. Suit for declaration, permanent injunction filed by the plaintiff respondent.
Plaintiff respondent.
My lord, dismissed by the learned trial court. Appeal preferred. My lord, the judgment and decree was overturned. Against that, my lord, I have come before my lord. My lord, the appeal has been admitted. So this honorable court sitting in division,
any execution filed?
No.
My lord, not to my knowledge.
My lord, before my lord.
There
No.
filed.
Yes.
No.
But then,
my lord.
bola session.
He was perhaps
Bola
plaintiff.
session.
Plaintiff ছিল। আপিলটা আমরা করেছিলাম। প্লেন্টিফ ছিলে তুমি, আপিলটা আমরা করেছিলাম।
তাই তো বললাম।
তুমি তো বলেছো বলা।
আচ্ছা। I stand corrected, my lord. I was a plaintiff. My suit was decreed. Learned lower appellate court, my lord, it overturned the decree. So now this judgment and decree is staring in my face. A division bench of this honorable court, my lord, has been pleased to admit and express the desire that the appeal would be heard on substantial questions of law which have been framed. Now, my lord knows, my lord, now the law is, apart from the substantial questions of law which have been framed, if it so comments to your lordships that your lordship would hear on other substantial questions of law, my lord can definitely hear it. But
first of all, as regards to the other respondents,
the service, my lord, is complete in terms of my lord's order.
And my lord, so far With regard to-
এইভাবে করিস
Yes, yes, yes.
Step by step.
এখানে তোমার দেখো না
Because
ডিগ্রিটা কমপ্লিট করতে হবে তো, নাহলে তোমার হবেই কি করে?
সব হয়েছে
initially the service is of prime importance.
my lord
Thereafter, we can proceed.
my lord now my lord kindly seize my lord's last order my lord before my lord seize the affidavit of service last order my lord 5th February 2014
Yes, from the affidavit of service. Respect of Raushanara Begum, notice could not be served, and from the track concern, it also reveals that the was blocked. In respect of respondent number 5, who is a performer, respondent of the DL and has the respondent number 5 been served?
the 4
No, 5. BL and LRO?
my lord yes my lord I have my lord sent my lord the affidavit of service my lord is there
BL and LRO. Learned Counsel, the report is not complete.
my lord your lordship is saying the report in respect of the pro forma respondent
BL LRO. He
is the pro forma respondent
former respondent.
no relief is sprayed against him in the appeal as well far less to say at the interlocutory stage I am today praying for a stay of the operation of a decree which is in favor of the respondents number 1 to 4
Learned Counsel,
my lord
it is this one from the affidavit of service. It reveals the status as on 15th of February.
My lord.
Now we are on 26th of February.
My lord. But since the matter was directed to appear, my lord, hence the affidavit of service, my lord, was prepared in terms of my lord's order. My lord directed the matter to appear, my lord, on 19th. Accordingly, the affidavit of service, my lord, was prepared.
And in respect of Roshanara Begum,
my learned friend is appearing.
দেখুন আমরা তার হয়ে appear করছি কি?
You are representing Roshanara Begum.
My lord, I am
Respondent
appearing
number 4.
No. 1, 3, 1, 2, 3, 7 and 8.
4?
No. প্রথম অর্ডারে লেখা আছে।
I have again sent it. I have again sent it in terms of my lord's order. My lord, kindly, my lord, permit me to place my lord's order.
I've gone through.
But I am banking on the findings of this honorable court that the husband is served at the self same address at the self same time, and in respect of the wife, the door is locked.
That is not the fact, Learned Counsel. In respect the track consignment shows the result up till 13th of February. Hopefully, it has been served in the meantime. It is not of last 15 days or last 13 days have passed by since 13th of February.
What I can do is
let the matter appear tomorrow.
My lord.
In the meantime, you furnish the latest position as regards to service. Hopefully, I think it has been served upon Roshanara Begum. Because this is of 13th of February, where it has been stated that Shadgachia.
Yes, this has been sent, my lord, on 9th.
On 9th, but the result is of 13th of February.
Yes, my lord, will it be my lord's pleasure to kindly pass it over, my lord? I come back, my lord, by taking the reports.
My lord, my lord, may I submit, my lord? My lord, from the application, my lord, that is can 1 or 2 other the application, that is leave to prefer an appeal. I have been served with an application marked with can 2, perhaps it may be 1 or 2 leave to prefer appeal. That application, in that application, my lord, the applicant says, my lord, judgment degree 17th November 2022.
Can
Leave to prefer appeal.
That would be, my lord, can two.
Can two. What a can two.
Can two.
Can two. Leave to prefer an appeal upon recording the death of the deceased Sheikh Ataur Haq.
no, can two is in respect of application for stay.
Then it should be can
Can
one.
can
It
one
should
of
be can
23 is leave to prefer an appeal.
Yes, my lord. Kindly take up the first paragraph, judgment degree dated 17th November 2022.
But
And-
also,
And my lord,
not at this present
my lord,
juncture.
kindly. Requirement is there. Well, I don't know whether any order of the learned registrar is there or not. That is why, my lord, I am duty bound to, my lord, to indicate, my lord. Second paragraph, Sheikh Ataur Haq died on 4th September 2022. Second paragraph of the application. So before the decree is passed,
Ataul Haq died on 4th September 2022.
so my lord, before the decree was passed, he died. And I find from the memorandum of
When the judgment was passed by the first
22nd,
appellate court,
22nd, my lord, 22nd, 17th November 2022. 17th November
17th November, yes,
2022.
this person has expired prior to that.
Prior to that, and my lord, I find from the decree of the appellate court, the respondent number 3 is the concerned person. His name is appearing in the decree. So, my lord, decree has to be corrected. I subject to correction, my lord. Whether that order was there earlier or not, that was not.
May I answer to my lords?
And brought to the notice of the court or.
No, this has been taken note of by the learned stamp reporter. Kindly take up, my lord, the memorandum of appeal, the back sheet of the first page. Record দেখবি নাকি?
দেখবো শুধু তো রেকর্ডটা ধরে বসেছিলাম তো দেখতে গেলাম তুমি দেখছিলে
My lord has
Lots
seen.
of things are written there.
Yes, yes. And then my lord kindly sees the top endorsement and the date, 16th October 2023.
Defect removed.
Yes.
As regards to the first one, the memo of appeal needs to be valued at its right place.
But all
of the preamble.
but the defects which have been noted have been removed, and there is an endorsement of 16th October. And thereafter, my lord, the appeal, my lord, went for admission before the Honorable Division Bench. Before, my lord, the defects are removed, it could not have been placed. Then, my lord, kindly sees, my lord, a previous order. A previous order when the self-same Honorable Division Bench released the matter from the list because the defects were existing and not removed, with liberty to the appellant's learned advocate to remove the defects.
আমাকে তো কপি দিয়ে ওগুলো এগুলো আমার নোটিশে আসছে
যেগুলো সেটা তো জমা পড়ে যাওয়ার পরে ডিফেক্টস গুলো ধরা পড়েছে।
আরে কপি দিলে হচ্ছে
আরে আমার কাছে তো সেই কপিটা। এবার
দেখে নি রেকর্ডটা দেখে নি।
My lord has seen, my lord, the 3-line order passed by the division bench, presided over by Justice Tandon, release the matter from the list, and let the matter go out of list, liberty to the learned advocate for the appellant to remove the defects, cure the defects.
That is of 23rd of August 2023.
My lord. And thereafter, my lord would see the endorsement of the learned stamp reporter, 16th October 2023. Thereafter,
6th October. But I think that is in respect of the first two defects.
No, my lord, there cannot be any, my lord, part endorsements, my lord.
Because
and my lord, the Honorable Division Bench.
Whether degree has been corrected or not.
The Honorable Division Bench, the Honorable Division Bench, my lord.
The decree passed by the first appellate court.
Yes. Whether that defect has been removed or the degree is corrected, my lord, so far, my understanding, my lord, a record to be gone down to the my lord, appellate court, thereafter, my lord, degree to be corrected and thereafter reset. Right.
Let the judgment and decree be stayed and sent down wherever my learned friend wants. And let it come whenever my learned friend wants. Defective admission হয়েছে।
কোর্টের নোটিশে এনেছো কিনা
appeal is admitted, stay is my right.
It has been brought to the notice of the court, my lord. None.
The details of the appellants and respondents are not there.
Yes, in the memorandum appeal, in the decree, my lord, it is there. After the order, judgment of the trial court, appeal court.
My lord kindly takes up the memorandum of appeal. My lord kindly comes to the last 5 pages.
Judgment of the first appellate court, judgment of the trial court.
My lord kindly sees the last 5 pages.
Decree.
Decree.
Yes.
Hmm.
Then there my
Title,
lord would find.
title,
What are you mentioning?
title appeal degree, title appeal number 6 of 2022.
Whose name? Whose name?
Sheikh Ataur Haq. Different respond number 3.
Respondent number 3. Ataul Haq,
Yes.
son of Sheikh Abdul Hamid.
Yes. Substitution they are seeking, my lord, in respect of that person. And he was died prior to degree was passed. My lord, whether that defect was brought into the notice of the court and that was removed by correcting the decree.
From the copy of the decree, it is
Is-
not revealing so. It is revealing that the name of Ataul
Is appearing.
Haq is there.
Yes. So, my lord, it was defective, subject to correction and what else?
No, let me understand. I shall reply to my learned friend's submissions. Let us understand what does he say. Today I am before my lord. I am praying for stay of operation of a judgment and decree.
Learned counsel.
My lord.
The judgment of the title appeal was passed on
17th November
2022.
My lord.
While Ataul Haq,
My lord.
respondent number 3,
My lord.
is said to have expired on
4th September
4th of September 2022.
2022.
Where does this date my learned friend gets?
It is from their application.
From my application. From my application. I'm not pressing that application for a moment. Where is it on record, my lord? I need to understand. Now kindly seize this.
From your application, as has been stated.
From
by-
his
I
application.
kindly, my lord.
Otherwise, it is as per my lord, order 22 rule 10A, my lord, it is their duty to inform
on
us
the court.
of the court. It is their application.
My lord, kindly seize, my lord. He is saying Ataur, my lord, he died in September, and the decree, my lord, has been passed in favor of my lord Ataur, against Ataur on this date. Ataur was, my lord, sufficiently represented by other 2 persons who are the heirs and successors and who are already on record. Will a decree against a dead man affect?
Who are the heirs and successors of Ataur?
Firoza Begum Sheikh, Ayesha Sabnam. My lord,
4 and 5.
I find, my lord, their names are not appearing in the appellate degree.
Firoza
Begum Sheikh
Begum Sheikh.
and Ayesha Sabnam.
One name. Firoza Begum Sheikh.
Widow and daughter of Ataur Haq.
Firoza Begum Sheikh, not the name is not there, and the other one?
Ayesha Sabnam. Both
Ayesha
names are
Sabnam.
not appearing in the appellate degree.
Ayesha Sabnam, Learned Counsel.
So they are not in record, my lord, in the appellate court.
They are not in the record.
They
That
are
is required to be-
daughter.
They are not in record in the. I say, my lord, today they are before my lord with an application that their interest is sufficient.
That is required to be rectified. Can an order be passed against a dead person?
My lord, kindly seize, my lord. It is, my lord, a suit where the collective interest was espoused by 5 persons. 1 person, my lord, died. A decree is passed. That decree is challenged before the Honorable High Court. The Honorable High Court admits. Now, if a correction is required in the decree, my lord, where should it go? It should go to the court which has passed the decree for correction. What happens in the meantime? In the meantime, that decree will be put into execution and my appeal would become infructuous. What is normally, my lord, the convention?
How can that be? How can that be?
Why, my lord? I put this question to
How
myself.
can that be? It cannot be. They can put into execution, but they won't be able to execute.
It is their suit, my lord.
No,
They
no,
were
but
plaintiff.
I am the plaintiff, and my lord,
You are the plaintiff. You were the plaintiff.
No, he was plaintiff.
that decree has been set aside.
Yes. Praying for declaration.
Yes, and injunction. And injunction.
You
So
had
they are interfering. They are interfering my possession. Hence the injunction.
Yes. They were interfering your position.
Yes.
You had won in the trial court.
Yes.
That has been reversed by the first appellate court.
Yes. Yes. Now, so my declaration goes. My declaration granted by the trial court goes, and he is now free to interfere with my possession.
Declaration, injunction, and recovery of possession.
No.
Declaration, and injunction. You are in possession.
Yes, my possession is being disturbed. Hence, stay and injunction. I am saying that stay part decree will be put into execution, and if it is executed, my possession is disturbed. But injunction not granted. Kindly grant me injunction. Send the record to the lower court.
It is his suit.
But kindly hear me. Then, my lord, kindly hear me. Let me place my application. I shall address.
Counsel, first of all, you were the plaintiff.
I am the plaintiff.
Before the first trial court.
My lord.
You had filed a suit praying for declaration and injunction restraining the defendants from doing whatever they were trying to do. You have won in the trial court.
My lord.
So they have been injuncted in the trial court.
Yes.
Thereafter, they preferred the appeal.
Yes.
It was reversed. The
Yes.
trial court judgment of the trial court was reversed.
Yes.
So they have won. They have won.
Yes.
But you are in possession.
So they are now free to interfere with my possession.
But the judgment passed by the first appellate court.
Yes.
First appellate court, on which they are relying.
Yes.
They were relying, they are relying, they will be relying.
Yes.
That has been passed against a dead person.
Yes.
Can that be enforced? It cannot be enforced at all.
My lord, I say kindly see, my lord, they need not enforce.
To that effect, I am passing an order. To that effect, I am passing an order.
Yes, but
so that,
let them not take an advantage of that judgment and decree and interfere with my possession.
They cannot.
No, let them not interfere with my possession, because there are other appellants as well. The dead man was not the sole, my lord. I'm sorry. I'm sorry.
The learned counsel appearing on the appellant Mr. Betal representing the appellants
1, 2, 3, 7, and 8.
Appellants and Mr. Betal, learned counsel representing the respondents are present. From the can 2, that is the application. What is the application? What is the
they say it is a
leave to appeal.
Leave to appeal.
That is leave to prefer an appeal. Leave to prefer an appeal. It reveals that. Which paragraph, learned counsel?
Para 1 and 2.
Kindly come to paragraph 2.
The
Paragraph
date of death.
Para 2.
From the paragraph 2, it reveals that Sheikh Ataul, Ataul, Ataul Haq, the respondent number 3.
See in the, my lord, in the appeal.
In the first appeal.
First appeal, yes.
Had expired on 4th of September 2022. That is prior to the passing of the judgment by the first appellate court, dated
17th November.
17th November 2022. So, The judgment passed by the first appellate court is in respect of a dead person.
Among others. Among others in respect of one dead person. There were other persons as well.
In respect of several respondents, including the respondent number 3, who had already expired on that date.
Respondent number 3 in the trial, appellate court, first appellate.
Yes, that has been mentioned.
Yes.
Full stop.
Who had already expired.
Who had already expired as mentioned above. Full stop. In such situation, let the what do you intend on counsel now?
Degree to be corrected, my lord.
The certified copy to be sent.
The certified copy has to go there.
In such situation, the learned first appellate court.
My lord, civil judge, senior division, Kalna.
That is the civil judge, senior division, Kalna, Purbo Bardhaman.
Title appeal number 6 of 2020.
Is directed to title appeal হচ্ছে 6 of 2010 ওর কিছু নাম্বার দেওয়া আছে CIS নাম্বার CNR নাম্বার এগুলো দিয়ে দেবে ঠিক আছে টাইটেল অ্যাপিল নাম্বার 6 of 2010 তারপরে CIS নাম্বার এত CNR নাম্বার এত is directed to rectify the cause title. Full stop.
Transfer
the certified copy filed along with the memo of the certified copy of the first appeal, which has been filed along with the memorandum of appeal, instant memorandum of appeal, be sent to the trial court, sent to the first appellate court for rectification. Immediately, a department to take step immediately in this regard. Department to take step immediately in this regard. Full stop. Kalna Bardhaman. How much time?
Lord, anything that goes from here and comes back, minimum 2 months time.
Let the matter appear on
special messenger. By Duronto will take that much time.
By Duronto?
No, he says special messenger if can be. I say special messenger with Duronto minimum that much time will take. Let us be pragmatic.
Let the matter appear on 15th of April.
The week thereafter, my lord, kindly cease.
Week thereafter?
Yes, because that, my lord, would be the holiday week.
No, Lord Counsel. 15 to 19, all have been marked in black or blue, whatever you say, not in red. April.
একদিনই ছুটি আছে মানে এটা পড়ে গেছে শনি রোববার পড়ে গেছে
Only one day we can have
11th
in the month of April.
ক্যালেন্ডার কি ভুল নাকি এটা
One day of holiday we can have. 22nd.
22nd.
of
I
April.
let there be a direction upon me to put in special messenger cost.
April মাস একদিন
In the meantime, let my possession not be disturbed. Kindly protect. In the meantime, let my possession not be disturbed.
Cannot be learned.
No, kindly.
Through legally it cannot be.
Yes. I said legal.
Legally it cannot
No,
be.
no. Legally or illegally, when my lord's order is there, they will not be able to do it.
Because among the respondents, one is a dead person. So legally, the title execution which has been filed, which might
No,
be filed.
execution he does not kindly. No, execution. Please, my lord. I am the plaintiff. He would not be able to file any execution in respect of his title is not declared. I am saying
all along there was
why, please. Lord, I am saying that there are twofold prayers in my application. The first prayer is stay. I am not pressing.
That will be taken up just as soon as the rectified first appeal comes.
Lord, but the other appellants, Lord, can Lord sustain their prayer for an injunction to protect their possession. There were, Lord, suppose 5, kindly permit me. There were 5 appellants. One died, Lord. He left for heavenly abode. 4 are still in possession. Lord, because one has left, Lord, 4 will not be able to protect their possession despite their appeal having been admitted before this honorable court.
It is admitted that you are in possession?
Yes, I am only saying status quo as regards possession.
You are in possession?
Yes.
You won't be evicted or dispossessed. You cannot be dispossessed.
Lord, kindly see my pleadings. I am saying that they are interfering with my possession. Lord, a one-line order that Lord restrains them from interfering with my possession. I am only seeking that.
And all along there was no injunction, my lord. They initially got a status quo order that has been.
If this was an innocuous order, my learned friend would not have objected to it.
Let there be an order of status quo in respect of nature and character.
Possession.
Sorry, in respect of possession, as on today.
I am grateful to my lord.
My lord, this order was passed initially. That has been, my lord, passed by our High Court, my lord.
That was during
in the long pendency of the appeal and, my lord, trial, my lord. This is the order passed by the Honorable Justice. Kindly have a look.
Why didn't you
My lord,
raise that earlier?
He's saying I have not wanted to, my lord, disturb him, my lord.
Those orders, Lord, are merged into a final decree. Today, my appeal has been admitted by this honorable court. I do not know what interlocutory order my learned friend is relying on. কপি আছে জাস্ট দেখে দিয়েছি দেখে দিয়েছি ডেটটা কি অর্ডারটার ডেটটা
হাতে লেখা তুমি এটা সঠিক কিনা 25/2
27 অষ্টআশি 27 অষ্টআশি 2000 25/1
2002
2003
2
আমরা আবার
ঠিক আছে
It will not be out of place to them to describe the form of the present case which post of such taking into consideration the present of the review of the present interference with the supplement it is to mention that observation made herein will not be binding upon the developed to when the suit will be heard. On merit learned concept. On merit, it was disposed of.
Yes.
The civil division.
Initially was passed.
Let my learned friend make some.
Initially was passed by the trial court. That has been reversed in the vacated by the appellate court. Against that, my lord, the plaintiff came up
It
to
has
the
been directed that the
Lord, may I before my lord?
No. Returnable date কবে দিয়েছি হয়েছে 22nd April. This is 26th February. ঠিক আছে
So all along there was no order of
this order. If my lord is referring to this order, kindly hear me. Only one moment.
Let there be status quo in respect of possession,
my lord,
till 29th.
But there is no apprehension of filing, passing of this order.
Yes, I have stated so in my application.
My lord, without filing my affidavit, my lord, in an application, my lord, can pass and against a person where my lord found a person is dead. All along, with my deepest respect to Mr. Chaturvedi, he says, my lord, they are in record, my lord. The persons are in record. I find, my lord, from the record, they are not there. And it is their suit. In the suit, they have lost by the appellate court. And my lord, another thing, my lord, the one last occasion, my lord, I have already indicated, kindly see the, my lord, an order that has been gone into by the Honorable Division Bench that the Amalnama based on which they are claiming, my lord, that has been framed, Division Bench framed that issue, that was registered.
Let there be an interim order of status quo in respect of possession till 29th, when the matter will be taken up.
My lord, first, my lord, for passing of this order, my lord, prima facie have to observe, my lord, who in what position, who is where in what position. Otherwise, it will
So
create.
now, my lord,
It is, my lord, my lord. Otherwise, my lord,
the appellants are in possession.
it is their saying. It is their saying. Because there are some
this is,
difficulties.
my lord, what, my lord, I was saying.
There
That
are
they intend to disturb my possession. So today they are disputing my possession.
No documents, nothing has been produced that we are disposed.
Let us understand.
My lord, since
The trial court-
2002,
Let there
my
be,
lord, since 2002,
let there be an interim order of possession.
but without ascertaining. My lord, in
No,
several
no,
judgments, my lord, Honorable
order.
Apex Court is saying that, my lord, without ascertaining, my lord, this type of order will create this, because, my lord, the possession is, my lord, a B plot. Maximum plot was, my lord, was acquisition. Government is there. PWD is there.
Is he getting the second
Electricity
appeal heard
department is
today?
there.
As on today, that is.
He is saying, my lord, he is in
6th of
possession.
February. If he is not in possession, he won't be in possession. If he is not in possession,
That has not been ascertained anywhere. So
let there be an order of status quo in respect of possession, as on today.
without even prima facie, my lord, satisfying who is in possession, my lord.
Oh yes,
That
prima
will create
facie.
difficulty.
No,
my
no,
lord.
the admission is a
In that
prima
point,
facie
my lord,
observation.
if my lord desires, my lord, I can bring
The
some
admission of
judgments that
appeal,
before,
the
my lord.
admission of appeal is a prima facie observation.
It is in respect of both of you. If you are in possession, then you will be in possession.
My lord, it
If
will
they are
create,
in
my
possession,
lord,
they will be in
it
possession.
creates some problem. That is why, my lord, in several, my lord, matters, my lord, the Honorable Apex Court is saying, my lord, prima facie have to satisfy before passing this type of order of status quo.
My lord, with the pace of respect, if I may answer this. My lord, the Honorable Division Bench, upon being satisfied with the prima facie case of with a prima facie case of title and possession has been pleased to admit my appeal. If that be the case, I am entitled to a protection. Otherwise, the intent of the Honorable Division Bench to protect my title and possession, that would be rendered infructuous. The respondents are desperate in nature, as my lord has just seen. They say that they are denying my possession, and that is the apprehension I have expressed in my application.
Lord, seize the, my lord, kindly seize the issue frame. তোর অ্যাডমিশনের অর্ডারটা দিন দাদা, পরিস্ট্যান্ডনের অর্ডারটা দিন। But on that, my lord, পরিস্ট্যান্ডন সাহেবের অ্যাডমিশনের অর্ডারটা দিন। অ্যাডমিশন অর্ডারটা বের অ্যাডমিশন অর্ডারটা এসএপি
Learned Counsel,
and
in the meantime, what about the service upon the respondent number 4?
Respondent number 4,
let the matter be fixed on 29th of February. On that day, you saw the service upon the respondent number 4. No.
As a lordship.
Regarding the defects, my lord, so far the
Thereafter, it will be sent for rectification.
thereafter.
From the affidavit of service. From the affidavit of service, it reveals that the respondent number 4, namely Roshanara Begum, has yet been served. Has not as yet been served. In such situation, let the matter be fixed on 29th of February. The Learned Counsel representing the appellants is requested to furnish
the proof of delivery on respondent number
4. Along with that, respondent number 5, that is BLLR.
I shall.
On 29th of February.
I have to take chair, my lord, for some difficulties.
Be seated, be seated, be seated. Showing the fate of delivery of notice upon the respondents number 4 and 5. 29th February.
His head started spinning, certainly.
Now you're okay.
No. Sometimes there are some blackness due to pain of backside, my lord, some blackness.
Now you are not a doctor, so don't say because of that. You better go and get a checkup.
I think that won't be. There will be something more problem. Not out of pain.
This is not something very strange. I am a lawyer, but I am medically diagnosing myself. It is because of this.
The main thing is that he is saying that blackout.
Some haziness, not blackout, some haziness.
It won't be out of pain only.
Yes,
that's the main thing I'm trying to say. Out of because of some problem in the heart.
Maybe.
Lord, with my lord's kind leave, I escort him out.
This is the best example.
He's most our respectable senior. I always admire him.
I'm
Grateful. Grateful.
33 Lordship, I
Up any of the hearing matters till now.
this is a stay application.
No, one thing can be made that after the recess, hearing can be taken up. Part heard first, thereafter hearing. Each and every day, after the recess, hearing will be taken up. First of all, the part heard matters, thereafter the hearing matters. And during the first half, the to be mentioned an application. And no, and the application to be mentioned an application. It equals first first half থাকছে হচ্ছে 15 to be mentioned and application.
Very good touch.
Otherwise, next. Thanks for the suggestion.
Lordship, I am for the appellant, my lord.
33.
Yes.
I am for the respondent.
Defendant is the appellant before your lordship. The appeal has been.
One application is pending. Can one of 2022?
That is the application, stay application, lordship.
Yeah.
Initially, at the time of admission of this appeal, stay was granted by their lordship, Justice Horish Tandon and Justice Prosenjit Biswas.
Can one of them cannot be taken up?
Yes. Now, the respondent has filed an execution case. That execution has to be stayed. The execution was stayed for a limited period of time.
White order dated?
Lordship, the white order the 5th of June 2023.
At the time of admission?
Yes. Can
5th of June 2023.
Yes, the applications are direct to serve copy of the instant application upon the respondent by speed post and shall file affidavit of service. An execution case being title execution has been levied against the appellant before
This is a suit for?
Suit for eviction. I'm the defendant.
You're the defendant tenant. If the entire appeal is taken up for hearing?
Your lordship, the paper book is ready, lordship. Your lordship can take it up.
Is there? Paper books are ready. Why?
Now, here and now.
No,
Not.
Your lordship can fix it, lordship. In the meantime, there will be stay.
Not in this week, my lord. After 2 weeks, your lordship kindly keep it, my lord.
Why after 2 weeks?
After 2 weeks, I'm saying.
Why after 2 weeks?
Because, my lord, I have to contact my client. My client is posted at Jammu and Kashmir. That is the difficulty. Therefore, I don't have any papers, even only their paper book that is with me.
Small papers.
Copy of
small papers.
No, plain written statement,
No,
evidence, copy of evidence. These are not with me.
You have the instruction, not the material instruction.
I have the instruction. No. So far, material instruction is concerned with regard to that. There is no difficulty.
So
those papers I require. I will ask him, my lord, either to depute somebody to provide me all the papers.
You have the paper book with you.
Only the paper book, only to court judgment. But at the time of hearing, I have to substantiate your lordship.
Henceforth, along in the paper book, be kind enough to give the plaint and the written statements.
But that is
yes. Otherwise, it becomes a
that is the
hindrance.
In respect of the exhibits, the exhibited documents are lying in the law court record. We are not getting access.
And I have to go through the record. That is the difficulty here. Otherwise, my lord,
the copies of exhibited documents.
Lordship may fix the appeal, lordship, and there will be state till disposal of the appeal, lordship. This is the normal
after
practice.
15 days.
Yes.
There is interim stay.
There
But
was
in
an-
that case, your lordship kindly don't dispose it of, because I am telling it to your lordship, in case this would be taken up along with the appeal, my lord. Why I am telling it to your lordship, my lord, in case, my lord, the application is disposed of, in that case, I will have a claim before your lordship, so far the occupational charges are
We
concerned.
are paying the
Already in the
occupational
title
enhanced.
appeal, my lord, that order was there, it is with me.
Yes, we are
But
paying
I am
that.
not on that.
Enhanced rate we are paying 2000 rupees.
হ্যাঁ সেটা কি
হ্যাঁ,
দিয়ে যাচ্ছে সেটা?
yeah, we are paying that. We are paying the enhanced amount. It was 150 rupees was the range. It was enhanced to 2000 that we are paying. Therefore, their lordships have observed.
Where is the, is there any order in respect of the application paying for stay?
Yes, yes. The instant appeal has been admitted upon framing of substantial questions of law. And in the event the appellants are evicted from the suit property, it would cause immense injury to the appellants. This is the observation. Second page of the order.
Admitted upon framing the substantial, and in the event the appellants are evicted from the suit property, it would cause immense injury to
Yes.
the appellants.
এতে কি-
We therefore pass an interim order of stay of the aperture title execution
We
case
are paying that.
for a period of 6 weeks from date or until further orders of this court, whichever is earlier.
Yes.
The instant application is made returnable. So,
We
consent of
Then
both
it will
sides-
be, because he is saying that he is.
We are paying 2000 rupees occupational.
Nin. Nin.
না না করে যেতে করে যেতে।
Let the application be disposed of till the appeal is disposed of, stay will be there.
Yes. According to my learned friend, he is making the payment. In that case, there is no impediment. I am not asking for any reassessment or enhancement, anything.
He is, according to him, he is making the
He is
payment.
making
Yes,
payment.
According to you, are you receiving the payment?
My lord, I have to take instruction in that case. That is the
We
difficulty.
are paying the occupational.
And my difficulty here is that, my lord, since my client is, my lord, no, I am telling it to you, it is very germane to this matter.
For that learned counsel, 2 weeks is 2 weeks not required.
It is required. Why I am, that I am telling it to your lordship.
But
In
can
case of
you-
other employees, my lord, simply, my lord, other cases, my lord, simply we make a call and we get the information. Here difficulty is that he is a, my lord, employee of border security force. By making a call, I cannot make a direct contact with him. That is the difficulty. After 15 days, your lordship kindly fix this matter, my lord. I have no objection.
The learned counsel representing the appellants submits that the appellants are paying occupational charges of rupees
2000.
2000 per month regularly to the respondent. Full stop. On consent of paragraph, on consent of the learned counsels, the application being can one.
Can one. Yes, 22. And 1 of 2022.
এই ক্যানটা কোথায়? Affidavit of service. Affidavit of the application praying for stay of the operation.
Stay of the execution case, Lordship.
Stay of the title execution. Stay of the title execution case number 9 of 2017. কি বললাম সেন্টেন্সটা? Counsels of both sides. The title execution case number 9 of 2017 is stayed till the disposal of the instant appeal. Full stop. That's the application being CAN 1 of 2022 is disposed of. And on consent of both side learned counsels, On consent of both sides, the matter will be, the instant appeal will be taken up for hearing on date.
After the fortnight, any date? বৃহস্পতিবার না কোনো একটা বৃহস্পতিবার করে দাও সুবিধা ওই দিন কাজ কম থাকে লাস্ট উইকটা রেখো লাস্ট উইক বলে বলছি না যে কোনো এতে তুই 21 তারিখ হ্যাঁ বৃহস্পতিবার করে ওই তো বৃহস্পতিবার 21 14 তো রাখতে 14 রাখবে পারবে 14 এর মধ্যে না 21 রাখবে 21st March
Let them start. Let them start on,
No,
start on
it
14th.
is coming to 2 weeks only, Lordship.
On
21st of March.
21st of March.
Yes, 21st of March. We are on the last week of February. 1 week, 2 weeks. Yes.
21st of March, 2024. Under the heading hearing.
Grateful to your Lordship.
So, can 1 of 2022 dispose of?
Yes.
Matter is fixed on 21st of March.
Lordship. Grateful to your Lordship.
Learned Council, no adjournment.
No.
Because he has been kind enough to.
Yes.
And from tomorrow, my lord, at 2, my lord, all the hearing matters will be taken up.
From 2 p.m., hearing matters will be taken up. Anjura Bibi.
Yes. Your Lordship kindly see, not found again. Address is not wrong, nothing is there.
One minute.
Not found.
What is the address in the first instance? Court of first instance?
First instance, not found.
No.
Plaintiff.
Anjura Bibi.
Yes.
She was
Decree also, Lord. Anjura Bibi. আর প্লেনটাও তাই দিয়েছে যা ডিক্রিতে আছে সেটা আর কি করবো সে পারপাসলি নিচ্ছে না
Anjura Bibi. Title appeal decree. Suited decree. Okay.
It's hard price. All time it is come. Not found, not found, not found. That is the whole trouble. There is no remark that address is wrong. Friends.
Where is the decree of the trial court?
Decree of the trial court, my lord.
I have found the decree of the first appellate court. Where is the decree of the trial court?
Trial court, I am giving you my copy.
No, in the along with the memo of appeal.
Memo of appeal, yes, my lord, it is within my.
What should have been filed?
Memo of appeal.
Has it been filed? Suit for partition, learned counsel?
Not, not suit for declaration permanent injunction.
Why there are two titles? Oh, title appeal. Title suit 2 of 2012.
Yes.
Title suit the decree to the title suited decree, title appellate decree পেলাম, title suited decree আমি তো পেলাম না। Decree of the trial court, learned counsel.
Decree of the trial court টা দেখুন শেষের দিকে আছে। হ্যাঁ মেমো হ্যাঁ মেমোতে দেখুন go. থাকবে না দুটো দেওয়া আছে আপনার দুটো ডিগ্রি দেওয়া হ্যাঁ সরি
What is Anjura Bibi?
Anjura Bibi.
Wife of Jiaul Haq.
Yes.
Learned Counsel, will you be kind enough to go through the envelope, the address in the envelope? Anjura Bibi, wife of Jiaul Haq,
Yes.
village
Kochai,
Kechuahi,
Kochai,
Jadupur,
Jodhpur,
post office Komlabari,
Kamlawadi,
PS English Bazar,
yes,
district Malda, care of late Tabjul Sheikh, father.
Your Lordship also may telling this.
It is telling.
Address is correct. According to decree, address is correct.
Earlier, on how many occasions you have sent it to the same
I
address?
have sent thrice, madam. First occasion.
This is the third time.
Third time. Your Lordship,
What is not found? In all the instances, it has been returned not found.
Not found. Earlier also. বুড়ো হয়ে গেছে দাঁড়াতে পারছি না
So, what to be done, Learned Counsel, now?
Then, my lord,
in respect of the other respondents?
Other respondents, they already received. All.
None is being represented today.
But no one is here on behalf of them.
Nil. Paper publication.
Paper public.
Nil. In what is the language being spoken by these persons? What is the language being spoken by these persons? The Bengali or Hindi?
No. Malda, Bengal.
Bengal.
There is no Hindi.
The Learned Counsel.
My lord, if your lordship, may I request one thing? May send a administrative notice. Better administrative notice.
If that serves the purpose, then had she contested in the court of first instance, that is the trial court?
Trial court, I do not know, brother.
Yes, she had contested. Is dismissed on contest against the defendants with cost. This is in the trial suit, title suit, and in the title appeal.
Also,
dismissed on contest. Anjura. Where is Anjura? In the title appeal?
Title appeal. Anjura.
1 JA. 1 jaw. What are not found. In the Learned Counsel representing the appellants furnishes an envelope wherefrom it reveals that Anjura Bibi, the respondent number One JA, jaw.
jaw. Yes.
One jaw has not been served, and the envelope has been returned with the endorsement with the inverted comma মতো করবেন, not found. This is not the first instance, but this is the second instance. But there is only
Second
one
is-
envelope apart from this one. কি গেল সেন্টেন্সটা? And this is the second instance wherein the said notice could not be served and it has returned with the endorsement not found. In such circumstance, administrative notice be issued upon the respondent number 1JA, namely Anjura Bibi. Registry is directed to take steps immediately and to file a report on or before 3rd of April. Let the matter appear on 5th of April.
5th of April.
5th of April.
Not in the month of March, my lord. Last week of March.
Last week of March, there are several holidays. That's why it will be better on 5th of April. Huh? Same heading. Next.
Well, I am for the plaintiff respondent.
For the appellant, your lordship.
On application being CAN 1 of 23.
Let's stay of the operation of the order.
Day of operation. Suit for? Suit for?
Suit for eviction. I am landlord.
Landlord.
Landlord plaintiff.
I am praying for a note today, your lordship. My senior is busy in another court.
It is against order of affirmation or
My lord.
affirmation. Both the courts have passed in your favor.
My lord.
So,
May I propose, subject to lordship, kindly, takes up, the appeal for hearing. Upon filing, informal paper book, Let that be.
LCR? There, LCR has arrived. LCR?
Informal paper book, LCR be dispensed with,
From where?
City Civil Court.
City Civil Court.
Kindly fix a date for tomorrow.
Nin.
But if your lordship fixed up the matter would be decided once for all. We are facing they are enjoying my property.
Praying for tomorrow.
As
but the order will be that the respondents will be directed to submit the cost, special messenger cost, and the record will be called for from the LCR will be called for from the City Civil Court.
All completed.
All completed, all completed.
Completed.
I am respondent. They are appellate. All completed.
That is why the LCR has not come.
LCR probably that I don't know. That has to be
Is it in the department?
That has to be ascertained. I don't know. This is their appeal. I am the respondent.
It is their appeal. Everybody knows.
My lord.
They are enjoying
my property.
That is also known. So
lord.
You will have to take the initiative. Who will take the initiative to dispose of the appeal?
Both of us. Both of us.
Both of us.
Joint.
Then you wait for them to take the
initiative.
initiative.
It has come as LCR. কালকে চলে এসেছে. It has come yesterday. আচ্ছা ঠিক আছে. He will ascertain. He'll inspect the department.
Both of you will ascertain tomorrow.
As your lordship.
It is up to you.
No, my lord, I want to get this heard, my lord, as early as possible, my lord.
But you are reluctant.
No.
It seems so.
No, my lord. I shall, my lord, then
Not
pursue.
today. Not today. Tomorrow it is being fixed.
As well as.
Apprise this court as to whether the LCR has arrived or not.
My lord. Much obliged.
Not today.
Thank you, Lordship.
Tomorrow it is being kept. Tomorrow.
My lord, in this matter, I am appearing for the appellant. Now, on the earlier occasion, my lord, I was conducting with the hearing of the appeal. Thereafter,
I am for the respondent, my lord.
thereafter, what falls from your lordship, my lord, your lordship has been pleased to give us liberty to inspect the file for advancement of our future argument. My lord, both sides, my lord, peruse the file, and we have taken notes of. Now today, as told, my lord, by the other side, he has some difficulty. So your lordship kindly fix a date, my lord, so that I can continue my argument. My lord.
Both of you are ready in the next matter? Then?
My lord, it can
tomorrow.
be on
Tomorrow.
Not tomorrow, my lord. I have difficulty, my lord.
For 7 days.
Huh?
Kindly accommodate
My lord,
for 1 week.
27th or 28th?
27th is tomorrow.
Kindly for
No, I'm saying about March.
No.
Then, my lord, 5th of March? 4th or 5th, my lord?
4th
My
of
lord,
March.
only one indulgence, my lord. If your lordship kindly takes it at 2 o'clock, my lord.
You are not here, so all the part-heard matters and the hearing matters will be taken up after exhaustion of the to be mentioned and the application hearings. If the to be mentioned matters and the application matters do not get exhausted prior to 1:15, then definitely at 2 p.m. the part-heard matters will be taken up. And if the to be mentioned and the applications get exhausted, then prior to that, prior to recess.
5th, my lord.
4th of March.
3 तारीख is my lord.
Learned Council 4th of March positively.
Oh, 4th of March, I have difficulty, my lord. Kindly makes it 5th, my lord. I just pointed out my junior, my lord. Fixed matter before the other court.
My part-heard
5th,
matter.
my lord.
Why not earlier? On 29th, 1st.
First, my lord, it can be.
First, it can be.
Yes.
But my lord, 1 week.
No, they will submit first, Learned Council. You won't submit first. On 1st of March,
2 o'clock. If possible, my lord, that indulgence I am bringing so that I can complete, my lord, my part.
let it be on 1st of March at 2 o'clock. Let it be.
Grateful. Grateful.
Division bench. Friday, division bench, some part matters
yes,
be taken up.
Well, good.
এটা ডেট দিয়ে রাখুন 1st of March. 1st March.
I'm here for the respondent, my lord, this matter. In fact, we have already completed our argument.
Completed.
Now we are only filing our
Notes of argument.
written notes of
And
argument, some submission.
Something is to be added.
Well,
Anything to be added?
I have nothing to
Nothing
add.
to be added.
I have
Citations.
citation I have given
You have
here,
given?
and I have already submitted the Xerox copy. And the submission that I had made, in addition to that,
At last, at the fag end of the day,
my lord.
hearing can be taken up. Yes, that's possible.
Recapitulating the submissions that were made on the earlier date, my learned friend had harped upon the point that the property, there are necessary parties have not been added, and for non-joiner of parties, the suit ought to have been dismissed. Wherein I had categorically demonstrated to your lordship by perusing through the sale deed, that is 157, sale deed number 157, my lord, of 2005, that the property was a demarcated property, my lord. And in view of the fact that the property is demarcated, the question of adding other persons who are no one to that property does not and cannot arise. And insofar as
Exhibited documents.
Exhibit 5, my lord, that was Exhibit 5. At page, that is the next at page.
What do we do?
particular exhibit, Your Lordship, it is clear that the property which was purchased by me was a demarcated property. Sale deed number 157 of 2005, dated 24/1/2005, Your Lordship.
A Xerox certified copy of a
Sale deed, my lord.
written in Bengali.
It's in
and
Bengali, my lord.
Which portion? The
The
schedule.
Tohudi
Schedule.
schedule, my lord. Another page 188.
Is there any English translation in the paper book?
I find one translation, my lord.
But
At page
how
190.
can it? How far it can be relied upon? That's
My lord. It's a replica of what has been written, my lord. Because
page number
192 is the translated,
192.
my lord. In the North Metal.
In the North Petal Road.
Metal Road. In the south, the property of Muzahar Mia. In the east, it's Sonua Kora. It's property of Sona Kora. And in the west, Neku Kora. The property of Neku Kora.
Yes.
So, my lord, it is categoric from the document itself that the property was demarcated, and it's an independent property which I had purchased. And when the property, which is independent in itself, there can be no other co-sharers, and the question of partition which has arisen does not arise. And since this property is owned solely by me, no other person can be necessary parties to the suit, my lord. Now, coming to the point of whether the appeal would have been maintainable or not, in view of the fact that the appellants have been trying to obtain orders from one forum or the other. The appeal which has been filed by my learned friends against the order of remand that was passed on 3rd of June 2016, Your Lordship. Thereafter, the matter appeared, after the remand, they appeared in the trial court. They filed 2 applications because only the limited question on which the order was remanded back was for appointment of a commissioner in order to ascertain the property and identify it. So once the matter was remanded, my learned friends, they appeared, they filed applications seeking change of the commissioner. That was rejected. Against that, they preferred a 227 before this court, my lord. They even filed an appeal. So once, if they have conceded to the order of remand and participated in the trial court, I put a question to myself, was it open for them to thereafter challenge that particular order of remand or not? But to that extent, I'll be relying on the judgment, my lord. This is the written notes of argument wherein I have already annexed the judgment, my lord. On the judgments of the division bench of our Honorable High Court, my lord may come straight away to page 13, Your Lordship, paragraph 11 of this judgment, which was reported in AIR 2009, Calcutta 24. Page 11. I'll refer to paragraph 11, Your Lordship, and I rely upon that. Upon an order attaining finality, now my learned friends have appeared in the court below, therefore the order of remand has already attained its finality. So upon an order attaining finality, it matters little as to whether it was erroneous. A party aggrieved by an order has to work out his remedies within the legal framework. If an issue or the entire list is concluded upon a finding being rendered and such finding remains unchallenged, it is no longer open to the party to undo the effect thereof at any subsequent stage or collaterally, unless it is demonstrated that the finding was obtained by fraud or the court lacked jurisdiction to pass the order. The hierarchy in the judiciary exists to afford litigants to climb up the ladder in pursuit of justice and to right a wrong committed at a lower level. But if a litigant accepts an order, he does it to his prejudice and binds himself thereby. So once they have accepted the order of remand, participated, made an application for change, rejected, they prefer an application of 227, and that also gets rejected by this honorable court. That is the next page. Your lordship will find the next annexure. It starts from page 19, the 2-page order, my lord. The petitioner complains of an order of November 16, 2016, by which the petitioner's application for changing an advocate commissioner was rejected. The point that the petitioners herein make is that the commissioner did not follow the appropriate procedures in course of his visit. The trial court noticed in the order impugned that the petitioner herein were disturbed by the police personnel, but accompanied the commissioner. The trial court also found that no prejudice has been occasioned to these petitioners as a result of the police personnel accompanying the commissioner. It is evident that the trial court applied its mind to the objections raised by the petitioner herein and found that the commissioner should complete the work. There is an element of discretion which is available to the trial court and which does not call for any interference in this extraordinary jurisdiction unless the exercise of the discretion appears to be perverse. Since the trial court considered the objections of the petitioner herein and gave reasons to overrule the same, the order impugned does not call for any interference, and CO 225 of 2017 is dismissed. So once they have participated, when the matter was remanded, they again challenged, and is it open for them to file the appeal or not? In my most humble submission, my lord, this appeal is not maintainable at the instance because they have accepted the order of remand, they have participated in the proceedings, and the order which was not in their favor by virtue of rejection of the application of change of commissioner was also assailed here. That too got rejected, my lord. So they cannot go on fishing for forums for expunging their cause, my lord. In my most humble submission, this appeal should be dismissed, your lordship, in view of such facts and circumstances, my lord. Another point I should point out, another fact, that the appeal which has been preferred by my learned friend that was filed on 27th of January 2017, whereas the CO, the application of 227, was filed on 20th of January 2017. So first application that they have filed is an application assailing the order of the trial court after remand. Thereafter, they have not sought for any leave from the court, and they have preferred this particular appeal at utter suppression of the fact and the actions that they have taken.
List of dates mentioned, furnished.
List of date has not been furnished, your lordship. If your lordship so desires, I can furnish the list of date, my lord. Because these dates of filing will not appear in any portion of this particular memo, or
These are not on the record of the appeal.
Your lordship keeps the matter tomorrow. I'll ask my junior. I'll not be there tomorrow or day after tomorrow. Your lordship can keep. I'll submit it, my lord. And today, my lord, I have already filed my
written notes of argument.
May I file my written notes of argument? I have submitted everything. I have considered the submission made by my learned friend about the specific demarcation. That is not, it is the finding of the trial court as well as the appellate court that there is no demarcation. And the subsequent order of appointment of commissioner or subsequent order passed by the honorable court, that will not affect my right to prefer appeal. It is my right to prefer the appeal against the order of remand. So this is
let the matter appear under the heading to be mentioned day after tomorrow, your lordship.
Day after tomorrow.
To be mentioned.
To be mentioned.
Only for filing
only for filing the list of dates
by my learned friend.
তুমি মনে করো দেবে তুমিও দিতে পারো।
হ্যাঁ, dates are not important.
Written notes of argument have been filed on behalf of the appellants and on behalf of the respondent number 1. Full stop. Heard the learned counsels on behalf of the appellants and the respondent number one, full stop. The learned counsel representing the respondent number one has referred to some dates as regards to filing of the revisional applications and
Appeal,
uh,
as well as the appeal.
as well as the appeal. The learned counsel further submits that he intends to file a list of dates. Let the said list of dates be furnished day after tomorrow. Let the matter appear under the heading to be mentioned day after tomorrow on 28th.
28th.
Only for the list.
Only for the purpose of filing the list of dates.
Hearing complete.
My lord, concluded.
On that date, it will be made the CAV.
On that date, your lordship, my lord. Oblige your lordship.
পুরোটা দিয়ে দেবেন কিন্তু
When 41, I'm for the appellant, my lord. The matter is fixed on 19th, my lord. I have given notice to my other side advocate, my lord. He has accepted the notice.
It was fixed on 19th.
19th, my lord.
Oh. Those dates are over.
Yes, my lord.
Tomorrow. Intimate the learned counsel.
Now, my lord, it is very difficult to intimate the learned counsel because after 4:30, his clerk will not accept the notice.
Why not?
No, my lord. And the
any bar?
And the advocate filed wakalatnama in this matter, my lord. He is not a regular practicing advocate of this court, my lord.
You tried
Yes, my lord. I shall definitely try, my lord. And the list is itself.
intimating that the matter will appear day after tomorrow.
Yes, my lord. Day after tomorrow is.
So you'll get the opportunity.
Yes, my lord. To serve the clerk, my lord.
The day after tomorrow, sir. Otherwise, that won't be fruitful if it is kept tomorrow. It will be taken up day after tomorrow.
Yes, my lord. Yes, my lord. Moreover, this list is also a notice to the advocates, my lord.
Purpose next.
My lord, I beg to appear on behalf of the appellant. There is a talk of settlement is going on, my lord. Already the draft compromise agreement has been.
What about the
Yes, Mr. Shiva Prasad Ghosh is appearing, my lord. He is all along appearing for the respondents, my lord. I am praying for 1 month's time, my lord, so that in the meantime the settlement may be completed.
Let the respondent also submit with the same tune.
No, already I personally sat with the respondent was there, the appellant was there, the learned counterpart in the court below was also there. My client has already taken the entire brief because the counterparts in the courts below will sit together. And I am without brief.
Let the matter appear tomorrow. Thereafter, in presence of the learned counsel representing the
I shall
respondent.
intimate him, my lord. Over telephone, I shall intimate him.
Next.
43 Lordship, I am appealing with the appellants. This matter, Lordship, already up to trial court, I already submitted.
So the hearing has commenced.
Yes, Lordship.
What about the respondent?
Lordship, last occasion, Lordship, none of the appearing on behalf of the respondent.
None had appeared.
Lordship was directed to me. Another notice was given to indicating that if he is not choose not to appear, then matter may be taken up expertly. I also communicated. Yes.
You are representing the respondent?
Yes, madam.
Ready with the hearing? Can it be taken up?
Submission has not been completed.
No, that's why. We were waiting for you. Can it be taken up today?
Only 5 minutes remain.
Only 5 minutes.
So,
Take it up tomorrow.
Tomorrow it will be taken up. Please. Next.
Kindly fixing that time.
Time has already been fixed in general.
I know.
From after exhaustion of the to be mentioned list and the application, the hearing will be taken up. First the per heard matters, thereafter the hearing matters. And if the to be mentioned and the hearing and the applications are not exhausted within prior to recess, then hearing will be taken up at 2 p.m. onwards. Next.
I appear on behalf of the appellant. I learned from his clerk of Mr. Sinha, who is appearing on
That
behalf
one,
of the
31, 32. You have completed.
Yes.
Yes, submission of the
Sinha has
submission of
not
the appellate.
completed. Other side respondent did not complete it. Therefore, he can't.
One set of respondent has completed,
Yes.
while the other set has not completed.
Yes.
The
Therefore,
other set is required to be heard, and thereafter it will be completed.
It will be fixed on day after tomorrow because Sinha is ill. Now Sinha is suffering fever.
Who is to submit?
They on behalf of clerk.
Day after tomorrow.
Day after tomorrow. Day after tomorrow.
এটা day after tomorrow থাক একদম ডেট দিয়ে দিন
Day after
day
tomorrow.
after tomorrow মানে
2 p.m.
28th of February.
Yes. At 2 p.m. my lord. The otherwise morning is taken time, therefore it is difficult.
2 p.m. 2 p.m. 2 p.m.
2 p.m.
Next.
And next 44, 45 or same.
Second appeal 31 and 32 are taken up together. Next.
47.
46. Oh, acha.
47, my lord. In this matter, my lord, I am praying for a week's time, my lord, in this matter.
Why?
Mr. Ritendra Banerjee is appearing for the appellant, my lord. He has some personal difficulty, my lord.
He was just here.
He was just here, my lord. He instructed me to take a week's time to kindly fix a date, my lord, on the next week.
What about the respondent?
That I am not aware, my lord. Madhumita Patro is appearing for the respondent, my lord.
Intimate him, the adversary, that the matter will be taken up tomorrow.
Yes.
Thereafter, let us see.
Okay.
Next.
48.
48, I am for the appellant. But in the meantime, your lordships passed the order. I came to know from the client that the respondent have.
You are for the appellant?
Yes, ma'am. The respondent have transferred the property to third party. That's why they are not perhaps appearing today. Long back that it has been transferred to any third party.
So,
So, my lord, unless and until they are made party,
so you will have to take step.
yes, my lord, I give some time to collect the names from my client and then made them party. Your lordships, very difficult to collect, but the Ratan Ghosh who has died, thereafter his wife has been made party, and your lordships allowed last week, last
48.
give some my lord at least 3 weeks time.
In 48, the learned counsel representing the appellants seeks an accommodation of 3 weeks, as has been submitted by the learned counsel that the property in question has been transferred by the contesting respondents in favor of third party. He further submits that the third party in favor of whom the said property has been transferred is required to be added as a party. As such, necessary steps are required to be taken. On this ground, the learned counsel seeks accommodation of 3 weeks. Let the matter appear
That to be mentioned, my lord.
Let the matter appear on 18th of March. Under the same heading. Next.
If
same heading.
Same heading, my lord, difficulty is this that the application is required to be made.
You
That's
file
why-
the application, you take step, thereafter it can be placed under the heading application.
Application,
Until now,
otherwise
until at this present juncture, there is no application pending.
well, that's why I praying for to be mentioned on that day.
Then it will go backwards.
Or the application. All right, I have no objection.
Let it be under the heading hearing. It might be that the information which we have received is not correct. Might be.
No, that's why they are also not appeared. The last 2 occasions they are appeared.
They had not appeared.
Last 2 occasions they appeared.
They had appeared.
They also not know.
They also do not know.
They also do not know.
Very good.
Well, my lord, I was praying, my lord, there are additional copies in the department. If my lord may kindly direct a copy to be given, my lord. Or, my lord, my learned friend, my lord, is for the adversary, can give me, my lord.
You are for the respondent.
I'm for the appellant, my lord.
You are for the respondent.
Yes.
How many sets have you filed? 7?
8.
8.
My lord. হ্যাঁ তোমাদের কাছে আছে he was not there, my lord, on the last occasion. Somebody কোনো senior আছে হ্যাঁ উনি আগের দিন বলেছেন যে ওনার কাছে কপি আছে I have filed some, my lord, but my lord, unfortunately, my lord, my copy is misplaced.
peculiar circumstance.
But then, my lord, I'll collect it from my
Yes,
learned friend. my
that
lord.
will be better. Be kind enough to hand over at his own cost.
Yes, yes, definitely. my lord.
Um,
Kindly grant me some time.
how much?
1 week only, next week. I'll not run away, my lord. I wish to do this matter, my lord.
Anything to submit it, Lord Counsel?
But item 51, my lord. I'm only praying for a day after tomorrow. Because, my lord, pursuant to lordship,
Matter appear tomorrow. Let the matter appear tomorrow.
no, my lord, only this, my lord,
In the absence of the other
no,
side.
my lord, other side is, my lord, I have serviced 2 times. They did not appear. Even that part of the last occasion, pursuant to lordship directions, I have already served this. But one, my lord, envelope will be returned. It has been stated that cannot be located at this time. So, my lord, earlier on respondent number 3 was, my lord, not received.
Not be located. The
Yes,
same address as
address
same
cannot be
address-
located.
Same address as it
Yes,
appeared in
yes.
the term.
Not located.
So the person is a powerful one.